physical disability and may need to very abruptly take a break.
Okay.
So that would be a short break, but I know you've had a scheduled morning break, and we may or may not need a break before that.
Yeah, of course, we can accommodate Mr. Boynton to any extent necessary.
And I also had a question about Mr. Kaplan's exhibit list. I noticed he listed Mr. Boynton's pre-filed testimony, but did not list any of the town's responses to the siting board discovery. So I just wondered how you'd like to number those. He did number Medway 1 through 4, the company's responses to the town's information requests.
Company's responses to the town's information request, but are you saying that the exhibit list doesn't contain the town's responses to the EFSB questions?
Correct. I didn't see it. Maybe I missed it, but.
Let me ask Mr. Kaplan. You're on mute, sir. You're muted.
Sorry, it takes about 30 seconds between you unmuting us and us being able to hear us. I did inadvertently leave off those exhibits, and I'm happy to add that to the exhibit list. I also left off the EFSB exhibits 1 through 3, I noticed. So when I was going to submit a follow-up, I'm happy to add those exhibits.
That would be helpful. Thank you. I appreciate that.
So will those be
Sure.
numbered? Will those be numbered sequentially, or will they have a different?
So we've been, the responses to the IRs are just labeled as however they were sent. So if it was MDY1, that's what it is.
Okay.
I'm just going to wait a minute.
But what I'll do is, before I send it, oh, I'm so sorry.
Go ahead, Al.
Before I send it out into the EFSB, I'll send it around to everybody just for their final look, so I don't have to keep correcting errors on my part.
Okay, that's very helpful. Thank you, Mr. Kaplan.
Thank you.
I'm just going to wait another minute just in case there's someone from the, if someone from the public wants to join the YouTube. They're supposed to be here. We're supposed to start at 10 o'clock. So I'm just going to wait a minute. I'll be right back.
Mr. Kaplan, I noticed Mr. Jablonowski and Mr. Callahan are on the attendees list. Would you like them to be promoted? I don't know if we're going to get to those questions today. Yep. Thank you.
I don't know either, but just in case, they should be included if it's okay with you, Wayne.
Yep. And Mr. Bernstein, I've seen a Allison from the town of Medway here since 9:30. I'm not sure if that's one of your witnesses or not. Okay.
She's an assistant to Mr. Boynton, so she's not a witness.
Okay. Would she prefer to be on the panel, or would you prefer her to be on the panel for whatever purpose, or no?
Michael, no, right?
No, just observing.
Thank you.
Thanks.
Could you tell me what her last name is in case her name comes up?
Potter, P-O-T-T-E-R.
Thank you.
Okay, and I think that I'll start by just giving a general introduction for the record, and then I would swear the witness, and Mr. Bernstein, I'm sure you have direct examination for the witness.
Yes.
Okay. So let's commence on the record. My name is Robert Shea. I am the presiding officer in this proceeding. This is the proceeding of regarding Medway Grid LLC, EFSB 22-02. And let's see, I'll identify the people who are on from the siting board staff who are on this call. It's just, at this time, it's just Wayne Wong, our assistant director. I expect that Andy Green may join us at some point, and Joan Foster Evans may join us also. I'll ask counsel and then Mr. Yorkis to introduce themselves, and then Mr. Bernstein, I'll ask you to introduce your witness and I'll swear your witness. So counsel, starting with Mr. Kaplan, could you please introduce yourself?
Sure. On behalf of Medway Grid LLC, Andrew Kaplan and Paul Connolly, Pierce Atwood, 100 Summer Street, Boston, Mass. 02110.
Thank you. Mr. Bernstein?
On behalf of the town of Medway, Jeffrey Bernstein, BCK Law PC, PO Box 205, Woodstock, Vermont 05091.
That's great. Thank you. Mr. Kaler?
Hi, good morning. Mike Kaler from the law firm of Keegan Moreland on behalf of Eversource Energy.
Thank you. Mr. Yorkis? You're muted right now, Mr. Yorkis. You're on mute.
Yep.
There we go.
I apologize. Paul Yorkis, spokesperson for Medway Enumerated Parties, 7 Independence Lane in Medway.
Okay, and then now, thank you very much. Mr. Bernstein, if you would introduce your witness, I'll swear the witness.
Thank you very much, Mr. Shea. Good morning to everyone. Good morning, Mr. Boynton. Could you please state your name, business affiliation?
Just a moment. Doesn't the witness have to be
Oh, I'm
sworn?
sorry. Absolutely.
Yes, Mr. Boynton, would you raise your right hand? Please raise your right hand. Do you swear that the testimony you will give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Let the record reflect that the witness has been sworn. Okay, now, Mr. Bernstein, you can introduce
Okay,
you.
I'll try again. Thank you very much. Good morning, everyone. Mr. Boynton, could you state your name, business affiliation, and business address for the record, please?
Certainly, Michael Boynton, Boynton. I am the town manager for the town of Medway, Massachusetts.
And can you state your business address?
155 Village Street in Medway, 02053.
Thank you. Could you briefly describe your educational and professional background?
I have a bachelor's degree in political science from Fairfield University, a master's of public administration from Framingham State. I have been in local government now in my 34th year. The manager since 1995, originally with the town of Mendon, and then towns of Sutton and Walpole before coming to Medway here in 2014 as town administrator and now town manager.
Thank you. What's been your role, Mr. Boynton, with respect to the proposed Medway grid project on behalf of the town?
I am the chief administrative officer for the community and was tasked by the select board in overseeing this process. Excuse me 1 second while I take a sip of water. Excuse me. Wow, this is off to a good start. Excuse me 1 second, that caught me by surprise.
Don't worry, Mr. Boynton. Take as much time as you need. There's no rush.
The board tasked me with negotiating with Able, now Medway Grid. We conducted several meetings with them and ultimately negotiated a host community agreement with them that was ultimately approved by the select board.
Thank you. Have you prepared any documents for this proceeding?
We answered several questions for EFSB on town responses. Also, essentially worked on the host community agreement at the time.
Okay. Have you prepared pre-filed direct testimony for this
Yes.
proceeding?
Yes, we did.
Okay, and I refer you to a document which has been marked as exhibit, just the exhibit MEB1. And it's a 6-page document with an attachment. Do you have that in front of you? And does the board and the other council present have that?
I have it on my screen. Yes.
Okay. Do you reckon? And so that is the pre-filed direct testimony, was that prepared by you or persons acting under your supervision?
That's correct.
And at this time, do you have any changes or updates or corrections to that pre-filed direct testimony?
I do not.
Okay. And then there are 6 information responses that the town prepared in response to questions, EFSB Town 1 through Town 6. Were those prepared by you or persons acting under your supervision?
Yes, they were.
And do you have any corrections or changes to those 6 information responses?
I do not.
Okay, thank you. Can you briefly summarize your pre-filed direct testimony, Mr. Boynton?
Yes. So I guess the best way to phrase it is that the testimony that we submitted on behalf of the town summarizes our involvement with Able Grid to date, Medway Grid. That from our initial meetings back in 2019, pre-COVID, to a handful of conversations that took place through 20 and 21, and ultimately negotiating a host community agreement in 22, we believe that the town of Medway was put in a good position in terms of protecting the interests of the residents, the community, et cetera, in the host community negotiating process. I think I categorized our working relationship with Medway Grid as positive, and that would be correct. And I believe that we stipulated or stated on a number of occasions that the town of Medway has experience in negotiating host community agreements and dealing with the EFSB process, as we went through the similar process, not identical, but similar process with the Exelon facility that was done in 2016, 2017. The town will hopefully be well protected by the HCA, and we have worked very hard to minimize impacts, negative impacts on the community. And that is the general summary of the pre-filed testimony.
Can you briefly summarize the process that the town undertook to negotiate and finalize the host community agreement?
With respect to the host community agreement itself, I asked 2 members of the select board to join with me, and we sat and negotiated with Medway Grid, and we ultimately achieved that consensus, if you will, on a host community agreement that was presented to the board in full board in July of last year. We made the document available for public comment. We advised Medway Grid that we would be doing so, and that if there were specific comments or concerns, that we may need to come back and address them. And I think we made those agreements available. We made the agreement available for a better part of a month plus. And then in August, we entertained further discussion. Further discussion with the select board, excuse me. And the board ultimately approved it in September.
With that, Mr. Boynton is available for questions. Thank you very much, Mr. Boynton.
Mr. Wong, do you want to start the questioning?
Sure. And I after that, I think, do you have a couple of questions too, Mr. Shea?
Yeah, yes, I do.
And I guess Dr. Yorkis probably does too, but I'll start and then we'll go from there. Good morning, Mr. Boynton.
Good morning.
I have a question to start off with from your pre-filed testimony, and I think you brought up just now also the public comment process. So just briefly, could you describe the general nature of the comments you had received on your HCA before it was finalized, and maybe talk about how they informed any changes that the HCA might have had?
They did not form substantial changes, and I'm having a hard time reflecting on specific changes that we made. But the comments were, and I'll put it in the general context. One, we don't like this, so there was a concern about that. But more so, there were some technical questions and technical concerns that we relayed back, some water use, and I apologize, I don't remember all of the specific ones, and I did not review those prior to this morning. But it was, there was some technical ones, there were some neighborhood concerns. And again, I wouldn't say that there were, there was nothing earth shattering in those, let's say.
Thank you, Mr. Boyne. I might circle back on that later, but I think next question I had was just in one of the company's responses to our questions, they specifically EFSB-T-9, the company described roadway traffic conditions in the project vicinity, Route 109 and 126, based off of traffic data. I was wondering if you could give me more of a qualitative feel, like description based off of your experience with traffic in the area.
Sure, that there is so the area where the site would be located is, there are some residential homes certainly, but if you go from just about the point of our Medway Fire Station, which is at 44 Milford Street, and you go west out towards the intersection of Fisher Street, while there are some homes in that area, there's also a small farm. There are also significant industrial or utility crossings that go through there. There are at least one major power line crossing that goes through there. There is a high pressure gas crossing that goes through there west of this proposed site. And there is a very large Algonquin gas switching or reducing station, I guess is the best way to put it, just west of the location. So there are some homes, and it's somewhat rural in nature. It is definitely not a, you wouldn't call it an immediate residential neighborhood type thing and a subdivision type dwelling. But there are some homes that have been there for a long time. There was one of the pieces of the site is currently a former gas station, I believe, years and years ago, and it's now an automotive repair building. Route 1 at the intersection of Route 126 and 109 on the northwesterly corner is Medway Fire Station. On the southwesterly corner, I'm sorry, the southwesterly corner of the intersection would be a small commercial center with a restaurant and a few professional offices in there. On the southeasterly corner, you would have Cumberland Farms, and on the northeasterly corner, you'd have a Dunkin' Donuts. So those are, and I hope I got my northeast west right, but I think I did. So Route 126 itself, not immediately residential. There are some condominiums that are located behind the fire station, some distance away from the immediate site, and immediately to the east of the site is a residential neighborhood of Little Tree Road and Rustic Road. And there is a natural wood buffer, wood line buffer, tree line buffer between the properties. And it's not, there's a lot of woodlands in there as well.
Thank you. Appreciate that. And I guess since it is somewhat residential in nature, I'd expect that the traffic in the area might be mostly a bit busier during the morning hours and the afternoon when people come back from work, or would you characterize it differently?
Yeah, without question, Route 109 is a corridor for commuting traffic. It's a busy stretch. Traffic eastbound is heavier in the morning, westbound obviously heavier in the evening. There is northbound traffic on 126 is heavier in the morning, southbound obviously in the evening. 109 does have its fair share of truck traffic that goes through there. It's not just a small residential street. It's a very busy street. Don't have any traffic counts to share with you, but it is what you would typically find in this part of the area. It's a connecting road from 495 to areas east of us.
I'm sorry, it's a connecting road. What? I couldn't hear you.
It's a connecting road from Interstate 495 to areas and communities east of us.
Thank you, Mr. Boyne. That's really helpful. I really wanted like a local description of what the traffic was looking like in the area. Okay. So sort of related to that, the company has relayed to us in their response to EFSB-CM-7 that that the town isn't seeking any seasonal restriction on construction, and I don't think the HCA lists any. But just for the record, could you state whether the town had any concerns about any restrictions on construction traffic or construction activity in particular seasons, or no?
Seasonal, no. In terms of hours of the day, yes. And we put that in the host community agreement, what they had to adhere to in terms of construction use. The concern that we would have obviously would be any type of construction during nights, weekends, holidays, and that the company would be required to get permission from the chief of police to exceed or go beyond what's in the host community agreement.
Thank you. And can you refresh my memory on what the hours were? I believe you had stated that the days and the hours. Did you specifically state no construction during holidays as well?
I'm going to go back and double check because I've got it in front of me right now. Exactly where I saw it this morning. We stated that Monday through Friday from 7:30 a.m. to 6 p.m. no construction shall be conducted on legal holidays.
Thank you. And I'm there too. I think it's, for the record, it's on the HCA at page 9.
Section 11A.
Thank you. Just have a couple more questions. So the company provided a preliminary hazard mitigation analysis that it says that it anticipates finalizing with the fire department later on. And I know you don't work with the fire department, but I was wondering if you're privy to any of those discussions and if you could speak to that.
Sure, technically they work for me, so yes, I am part of that conversation. The fire department, as with any major project, will spend time. They have spent some time, but obviously we'll get into the very details with Medway Grid, should this project be approved by your board, and then we will spend the time necessary to make sure that the fire department is aware of construction process, is aware of the materials to be located on the site, not just the batteries, but all the other materials that are located on the site, any of the characteristics necessary with firefighting or fire suppression on that, any issues that they might have with scene management or incident management, and obviously anything related to firefighter health and safety and safety of the community around us. Our fire department does deal with a significant number of different types of hazards in the community today, whether it's a major power station at Exelon with 1 million gallons of kerosene stored on site, to some heavy industrial uses in the East Industrial Park, and right down to dealing with the construction of large residential facilities that are popping up here in town.
Thank you. And you brought up quite a few particular subjects that the fire department might look at in the hazard mitigation analysis. I was wondering then, specifically for this preliminary HMA hazard mitigation analysis, if the fire department had expressed any concerns that they wanted the company to directly address.
Not that I'm aware of at this time. I think what we put into the host community agreement were general comments and concerns from the fire department related to having tools and equipment necessary, and also to be part of the process as this process moves forward.
Thank you. I wasn't sure if these are two different documents. I'm sure you're aware, the HMA and the HCA. I wasn't sure if you were speaking to both of them or
Just pure general terms.
Okay,
At this point, I will be honest, I am not familiar with the HMA.
okay. Thank you. One last question for right now. And again, this speaks to some plans that the company says will continue to be worked on in the future. But have you or anyone you worked who works for you been in contact with the company about a potential traffic plan for the project construction?
A specific traffic plan we have not worked out at this point, but again, we put the general parameters of it in the host community agreement. Stay off of the local roads, use only the state numbered roads, which are 109 and 126. And make sure that if there are any heavy or oversized loads, that they would be notifying the police department in advance so that we can make proper precautions. And
I'm sorry, so that we could make proper what?
make proper precautions, take proper precautions. And most importantly, that if there's any damage to those roadways, that they're responsible for fixing them.
Thank you. I appreciate that. Final question on follow-up question on that. For a project of this type, does the town usually expect some sort of traffic management, or is it more up to each situation as to whether there's a plan in place or not?
Each situation is evaluated independently, so it's not that it's just this type of facility. But again, having gone through heavy construction with the Exelon facility just a short time ago, many of the components that we utilized in the Exelon HCA were brought forward and as good practices, let's say, as it relates to this.
Thank you, Mr. Boynton. Mr. Shea, I'm all set for now. I might have more questions based off of you and any other questions that might come up. If you want to go ahead, that would be good.
Thank you. Thank you. Mr. Boynton, can I ask, do you have a copy of the host community agreement in front of you?
I certainly do.
Okay. I'm looking at section 6.d entitled Property Value Security Fund. Could I ask you to turn to that?
Sure, right there now.
Thank you. I want to find out the town's understanding of of this provision. Now, is a homeowner required to sign a release of the company in order to receive money from the Property Value Security Fund?
You're asking Mr. Shea whether the terms of this fund, not a legal question, but whether the terms of eligibility is that the homeowner would have to release all of his or her claims or its claims?
Right. I realize it is to some extent a legal question, but also I want to get a sense of the town's understanding. If Mr. Boynton doesn't have an understanding, but Mr. Bernstein, if you negotiated this and you have an understanding, I'll take your representation. But first, I'll ask Mr. Boynton if he has an understanding of this.
The pure terms of this do not require that the homeowner release or sign any releases. This is simply to provide an opportunity for them to access funding here locally.
Okay. And pardon me, Mr. Bernstein, you're not a witness, but you are an attorney. Is that what Mr. Boynton said? Is that in conformity with your understanding?
It is.
Okay. So just hypothetically, if a homeowner, for whatever reason, thinks that he or she has a cause of action against the company for $100,000, that homeowner can get some compensation through the Property Value Security Fund and then bring an action, at least theoretically, bring an action in any appropriate court for the remainder of the damages.
I think your phrase of theoretically is most appropriate. Yes.
Okay. All right. Do you know, maybe in rough terms, what the amount of the most recent annual budget was for the town of Medway?
The most recent annual budget. Well, let's see. Rather than guess, I will tell you exactly what it was.
Okay.
The annual budget as appropriated at town meeting was just under $62.5 million.
Okay,
That's a general fund. That's a general fund budget.
okay. And then with the host community agreement, it talks about a tax agreement. I think especially at the beginning, there's a reference to a tax agreement.
Yes, it does.
Are you familiar with that?
Oh, absolutely.
Okay, good. I don't believe the tax agreement, or I haven't gotten a copy of the tax agreement yet. Has it been finalized?
No, it has
I'm
not
sorry?
even been, it has not been negotiated at that. Let me back up. We have had discussions as part of the HCA relative to doing a pilot, a payment in lieu of taxes agreement. We have determined at this point in time that doing a pilot or some type of a pilot this early in the process is not advantageous to the town. And it obviously would be advantageous to the company. We do intend to negotiate this process if this project is approved by your board and it goes forward. We will negotiate a pilot agreement and then ultimately bring that to town meeting, which is where it has to go for approval. The issue being is that we have not determined the final starting value, if you will, of this project. So the town's desire is to have a pilot agreement that closely models what we did with the Exelon facility, which was a 20-year pilot that provided some $3.8 million in year one based upon a $210 million initial valuation. The town here has at a minimum value expectation that this facility will start off at $140 million.
140 million. That's very helpful. Thank you.
And if I may, the reason that it's 140 million at a minimum is because during one of the initial EFSB public hearing back in, I believe, July of last year, it was questioned as to how many megapacks, and Medway Grid at that time stated expecting 140 megapacks on the site. And 140 megapacks, a quick Google search indicated about $1 million valuation per pack.
I'm sorry, sir. I'm sorry, sir. I couldn't hear you. And at the time stated expecting 140 megapacks on the site. And
a quick Google search by yours truly identified each megapack having a value at that time of $1 million. So 140 times a million gave us the 140 million minimum valuation. What that does not take into account are any other infrastructure devices on the property that would ultimately be subject to the personal property tax. So we have a belief that the minimum value is 140, and that allows us some flexibility in figuring on any changes in value of the pack between now and then, and ultimately any type of increased value from other devices and equipment on site.
Yeah, I'd like to direct your attention to the second page of the HCA, which in the second paragraph, it talks about the tax agreement, and it has the language, a tax agreement of not less than $42,456,519.
Yes. How'd I
How
get
is
that?
that? Yeah, how is that number decided upon?
Stand by for 1 second. And
You see it, Michael? It's the second whereas.
oh no, I read it. I'm actually
Oh,
so
okay.
what we did is we have a chart, a table that we built. And so what we did was we took the 140 million as a starting value, and we multiplied that by the fiscal 22 tax rate that was in effect at the time, which was $16.93. So in making that assumption, 1693 times the per thousand, 1693 per thousand times 140 million gave us $2,370,200 was the pilot amount. The CPA, the community preservation amount, is 3% of the actual tax payment. So it'd be subject to that as well, and that would be an additional 71,000. So if you take those numbers out with a depreciation factor, and I believe we were giving them about 4% depreciation factor, but increasing the value by 2.5% tax growth factor, on an annual basis. It took us out over 20 years to that 42.4 million.
Tell me how a depreciation factor works in a pilot agreement.
So the reason that we want to do something like that, and we consulted with Sanssouci Corporation, a gentleman by the name of Glenn Walker, who assisted us with the Exelon piece. The reason that we would want to do a depreciation factor as well as the tax incremental factor is to take care of the taxpayers and make sure that there is an equity piece for all of the taxpayers in the community that also see an increase on an annual basis. But the depreciation factor is a negotiated number between the company and the town. If we don't have a pilot agreement, there is the possibility through just straight ad valorem taxing, where the company would go for a much greater depreciation out of the gate. Now, the greater depreciation is not in the best interest of the taxpayers, because once the amount is committed, so let's say that initial 140 million or whatever that final number is that we settle on is committed, that if that number, if there is a substantial depreciation in year 2 or year 3, or pick a number, that ultimately could be substantiated through the appellate tax board process if necessary, that would represent a substantial potential increase on taxpayers. So if you drop the value of that by $1 million in year 2 because they were able to demonstrate a depreciation on the equipment, that essentially represents $1 million tax increase that the rest of the taxpayers would have to pay, barring any type of a formal Proposition 2.5 underwrite.
I think you answered my next question, but I'm going to ask it just so it's easy to find in the record, and that is, tell me what the advantage of a pilot agreement is over, as you say, an ad valorem tax.
It maintains consistency and value, if you will, for the town over a prolonged period or a defined period. It also provides some type of an expectation for the company so that there is not a roller coaster effect. It provides some assistance to our assessors, who otherwise would be out there on an annual basis trying to rely on experts to make a determination on whether or not the company's assertions for depreciation factors, let's say, are legitimate.
I see. And with respect to a normal municipal tax, if enhancements are made to a facility, those enhancements are subject to tax.
Absolutely. And part of, as an example, the most recent pilot that we did was Exelon, that if there is a change in value, they are obligated to report the change in value to us. So in other words, if they went out and swapped out a battery pack, that would not necessarily be a change in value as it relates to the pilot. However, if they increase the overall megawatt output or containment, if you will, in the facility, that would constitute a change in value that would be subject to a higher pilot payment.
Okay, that's very helpful. That's all the questions I have. Thank you, Mr. Boynton.
Sure.
Mr. Yorkis, do you have questions for Mr. Boynton?
Yes, I do.
Oh, please go ahead, sir.
Good morning, Mr. Boynton.
Good morning, Paul. It's always lovely to see you on an early Monday.
Oh, yeah. I have a whole series of questions,
Not surprising at all, Paul.
so bear with me, please. Are you familiar with the March 10th, 2022 letter prepared and signed by Economic Development Director Barbara J. St. Andre that was addressed to Secretary Kathleen Theodoridis and sent to the attention of Jennifer Hughes, MEPA office, regarding Medway Grid?
I'm sure I've seen it, but am I familiar with it at the moment? No.
Mr. Yorkis, is that a document that's in the record?
It is not in the record at this point in time. Roman numeral 1.
Excuse me, I believe that it's exhibit MG6. I believe it was filed as part of the SEIR.
I think
All
you're,
comments,
I think
all
you're
comments
correct.
that were received are included in that filing. So this document that Dr. Yorkis is referring to is in the record.
Mr. Shea.
Yes, sir.
Mr. Shea, if I may, I'm going to need to take a short break. I shall be right back.
Of course. We'll take a break. Be back in 5 minutes. are off the record.
Thank you, Mr. Kaplan.
Are we all back?
Andrew stepped out. We'll be ready in a second.
Give us another minute.
Mr.
It's coming
Shea,
up.
Mr. Shea, if I may, what was the reply that, the document that was just referenced?
Mr. Yorkus would know that. Oh, the SEIR, Single Environmental Impact Report.
I just wanted, Mr. Kaplan had said that there was a number to it.
Yes,
It's in attachment A of the SEIR.
Yeah, we're off the record. Okay, so it's attachment A to the SEIR. I'm looking at the electronic file room, and the SEIR is broken down into 4 parts. Do you have an idea which part it would be at?
Give me 1 minute. I might be able to figure that out. What part of
Mr. Boynton, the exhibit number is MG-6.
You have all the exhibits available, Michael?
Apparently, I don't have that one.
I can send.
Yeah.
Will you put it on the screen?
I was going to ask if someone could put it up if Mr. Yorkus has
Yes,
more than a few questions about it.
yes.
We can do that.
Oh, that would be helpful, thank you.
Oh, we just need us to be able to, actually Mel needs to be allowed to share her screen.
Give me 1 second.
We're still off the record.
Ms. Sammer, yep.
Okay, let's go back on the record. We have on the screen a letter dated March 10th, 2022, addressed from the town of Medway, addressed to Secretary Kathleen Theoharides, Theoharides. And I believe Mr. Yorkus had questions about this letter.
That's correct.
Go ahead, please, Mr. Yorkus.
Thank you very much. On Roman numeral 1, on page 1, contains items A through F. And my question is, did the town of Medway receive any information regarding the suggestions in items A through F from Medway Grid? Were any of the requests in the letter included in the host community agreement that was signed on September 7th?
All right, so you have 2 questions there. Did we
Right.
get any feedback from the company? I am not aware of that. As far as the items that should be, some of these included in the host community agreement, yes, I'm looking right at snow storage. That was one piece that we added into the HCA.
Thank you. On Roman numeral 3, environmental and public health impacts on page 2. Item A, noise mentions several concerns and requests. Did Medway Grid agree to any of the requests? And were any of the requests included in the host community agreement that was signed?
Mr. Yorkus, it would be helpful if you could ask just one question and then move on to the next. So I don't know which one you want to ask first, just so the record's clear.
Sure.
Thank
Well,
you.
I thought Mr. Boynton answered the prior question where he indicated that snow storage was included.
I did. Actually, Paul, I'm okay with this. So did we add anything in? Yes, the host community agreement has a full provision about noise in there.
Thank you.
You're welcome.
Roman numeral 3B on page 3, and for wetlands protection mentioned several concerns and requests. Did Medway Grid agree to any of the requests to the best of your knowledge? And were any of these requests incorporated into the host community agreement?
Relative to wetlands protection, the town added a provision in the HCA in terms of permitting where the Medway grid will have to go through a full conservation process. So specifically, that's when we anticipate these issues will be addressed.
Thank you very much. Roman numeral 3C, other environmental issues on page 4 mentions tree removal and related concerns. Do you know if Medway Grid has agreed to those requests?
We did not address those items during the HCA. It's my expectation that that will be part of the Conservation Commission's process.
Thank you. Quoting from the letter at the bottom of page 4, and this is a quote, RMAT states that spills and or other releases of hazardous materials are expected with relatively easy cleanup. Did Medway Grid agree to any of these requests, and were they included in the host community agreement?
Mr. Yorkis, if I could ask you to clarify, because I don't know what, when you say requests, I'm not sure what you mean now.
Sure. I'm sorry, I wasn't specific enough.
That's all right, Paul. Let me see if I can take a shot at it.
Michael, if you could just, it might be better just to wait to see what the question is, because the quote isn't clear about requests.
Okay. I'll read the whole, if I may, I'll read the whole part of it. As it relates to tree removal, etc. The ENF does not address the scope of tree removal, which impacts air quality in the immediate area, potential creation of heat islands, and climate change, all of which should be addressed. Thus, the project may not emit greenhouse gases. There will be long-lasting effects from the tree removal. As noted above, existing trees with a diameter of 18 inches or more that will be removed should be marked on the plan. The applicant should present an explanation as to the justification for the extent of tree removal and steps to minimize the removal of existing trees and other flora. It should be required to propose mitigation, such as planting of trees elsewhere on the site or other locations in Medway, to offset the environmental effects of tree and vegetation removal. The RMAT Climate Resilience Design Standard Report states that the project promotes decarbonization, but does not take into account the release of carbon due to tree removal. The RMAT states that, quote, spills and or releases of hazardous materials are expected with a relatively easy cleanup. The type and quantity of hazardous materials are expected to be should be delineated along with any environmental impacts. Attachment A states that batteries will be disposed of in accordance with applicable regulation, but there are potential environmental impacts from batteries leaking while on the site, or if there is a thermal runaway event. And so my question, and I'll do my best, Mr. Bernstein, to try and clarify, is with that information prepared by an employee of the town of Medway, that is, and that information is on the record, has
Excuse me, Dr. Yorkis. So I just wanted to point out on behalf of the company that the company responded to all of these statements in the SEIR at section 5 and 9. So one of the requirements are, once the list of information comes through, the company needs to respond. So all of the concerns that you're listing have been responded to on the record in exhibit MG6.
and thank you very much, Mr. Kaplan. And I guess my question would be then, has the town reviewed those responses? And has the town agreed with those responses?
I'm not aware of anyone reviewing those responses. I have not sat with the folks to ask them that. As it relates to whether or not we agree with the responses, there has been no place to make that determination at this point. It will take place, I would imagine, mostly during the conservation process. The host community agreement was not intended to be a permit and a full special permit, if you will, to operate the facility.
Thank you. Are you familiar with the Medway Planning and Economic Development Board memorandum of August 15, 2022, sent to you regarding the Medway host community agreement?
Again, I did see it, but haven't reviewed it since August 15th of 2022.
Mr. Yorkis, is that anywhere in the record?
I am unsure, Mr. Shea.
It is, Mr. Shea, it is so Dr. York has included it as part of one of his 48 information requests to the company. I will look for the exact number, but that letter is included.
Okay, that would
I
be
will
helpful.
note that the company objected to that because that letter was prior to signing the HCA. So it seemed to the company that that was just an opinion that was provided to the town as a means of negotiations. But the negotiations were concluded after August 15th, and this agreement was signed September 7th of 2022. So, but I will find the specific. I will let you know where it is in a minute.
Thank you, Mr. Kaplan. On item 2 on page 1 of the memorandum contains a request to, and this is from the Town of Medway's Planning and Economic Development Board, requesting a modification to the language in item 6C of the host community agreement, changing the word renewal to implementation. And I'm wondering if that change request was shared with the Medway Select Board and with Medway Grid, and was that change incorporated into the final host community agreement?
Well, the final host community agreement is on the record in this proceeding. So it says what it says. But to the extent you want to ask if it was shared with the select board, if Mr. Boynton recalls or can find that out, I'm not really sure what the relevance or how it's likely to lead to anything relevant, but I don't object to the question.
Yeah, I don't.
It was exhibit MEP 17.
Right, MEP-17.
Yes.
I'm just going to call that up on my screen here and see, so I can follow this. So the question, Mr. Yorkis's question is whether something was incorporated into the HCA, and the objection from Mr. Bernstein is that we can see what was incorporated into the HCA. I understand the objection, but I'm wondering, while we can see the HCA, there might be a particular provision in the HCA that was responsive to Mr. Yorkis's concern. So, Mr. Yorkis, what is it that you want to know whether or not it was incorporated into the HCA?
Well, thank you for your question, Mr. Shea. And what the concern is that the that Medway Grid has requested a comprehensive permit. And the Town of Medway's Planning and Economic Development Board has concerns regarding that and regarding the actual project. They've stated them, I think, clearly. And while their concerns may not be incorporated in the host community agreement, which is part of the record, I think it is important for the members of the Energy Facility Siting Board and staff to understand and know that while the Board of Selectmen, Select Board, excuse me, have signed a host of community agreement, that it may not reflect accurately the position of all entities within Town of Medway government.
I'm going to I really object. This doesn't go to Mr. Boynton's testimony. Mr. Yorkis is free to offer in his brief whatever interpretation he wants to put on what another board or body that doesn't have the executive authority that the select board has with respect to the host community agreement. There's nobody testifying from, so we have their letter as part of the record, but that's about all. I really wonder whether we're just going down a
Mr. Shea,
Yes, Mr. Boynton.
we went through all of the comments, whether it was a public comment or an email comment. We went through all of it, including the parts from the planning board. If it made sense to include the changes in the document, and we did that. And unfortunately, I can't put my hand on the letter that Paul's referring to, and I didn't have the opportunity to hear him because he went quickly as to which section was involved. But quite frankly, if it made sense, we made the change. And with all due respect to that point, that I would concur with Jeff that at this point in time, to suggest that all of the boards are not necessarily lining up behind the select board is not an appropriate thing for me to testify to, because I also don't believe that's necessarily accurate.
Well, that's a separate question. Are all the boards lined up behind the select board? But you know, I think that you answered the question that Mr. Yorkis asked, which is that you say that when you got a comment, you did look at it and consider it for the HCA public comment or from another board within the town or whatever. I think that's a sufficient answer.
Thank you.
Thank you, Mr. Shea. And Mr. Kaplan, I appreciate your comments and thank you for them. What I want to do, if I may, Mr. Shea, is go to MEP 12.
MEP-12.
Can someone put that up on the screen if you have any specific questions to that?
I do.
Okay. Thank you very much.
The in a discussion on Thursday of last week, it was testified by representatives of Medway Grid that they did not use a consultant to prepare the decommissioning estimate. And my question for,
We didn't have to tell them whether we did.
I'm sorry?
No,
Sorry.
Yeah, Mr. Kaplan, you may not realize that you're unmuted, but I don't think
Yes,
what you
thank
said
you.
got onto the record.
That's okay. I didn't mean it to. I apologize.
Oh, okay, that's fine. All right, so continue, Mr. Yorkis.
And I would ask Mr. Boynton the same question I asked, and that is, how did the $15 million bond figure, how is that established? On what basis?
Thin air, legitimately. At the end of the day, we're talking about something that's at least 10 years away, for having to make a determination. We did not also engage a consultant, if you will, to look at it. But quite frankly, we looked at it and said, intuitively speaking, I guess, that there are a couple of scenarios that would play out here. Number one, if the site is clean and the company just ceases to operate, and they want to discontinue and that the site needs to have equipment removed, one would suggest, logically speaking, that $15 million is a reasonable number to remove devices from the site. Again, I mean, that's based upon 2022 logic and discussion. There could certainly be a part of inflation there. It could cost $500,000 to remove stuff from the site. It could cost $50,000 to remove items from the site. If the site was not clean and there was some type of a contamination point, then anything that we have here is completely useless because it's going to quickly become part of either a mass contingency plan program through the state DEP, or it's going to become a Superfund issue. And the town would obviously be asserting its rights in that situation. So on the notion that somehow 15 years from now or 10 years from now that the company just ceases to operate a facility and we want it put back to its basic format, that was a number that we negotiated. And then in the context of pure negotiation, that's where it came from.
Thank you, Mr. Boynton.
You're welcome.
Mr. Boynton, did you or anyone else within the town of Medway look at the information from the Energy Storage Association, in particular, two documents, end of life management of lithium ion energy?
You don't have to read the rest of the question. The answer is no, I didn't look at it.
Okay. And my last question so far is, you indicated earlier this morning that the town has followed the same process with Medway Grid, similar to the Exelon project in our community.
Relatively, yes.
Pardon me?
Relatively speaking, yes.
Would you agree that Medway Grid and the Exelon project have a substantial difference between the two, in that the Exelon project took place on land currently zoned for that kind of activity, while the Medway Grid project is not on land currently zoned for that?
Yeah, Paul, that's a fantastic question. That is an awesome question, because it actually speaks to the point of why we're here at this point and not actually going through the planning board's process. Part of our dialogue with Able Grid early on was the potential rezoning of the site. And in an effort that you and a few other folks led about petitioning, about not going forward with that, the town pulled that back to give you and the other folks a chance to present your case and concerns. So the difference being is that the Exelon facility originally went through the planning board process because it was properly zoned. So many of the items that we brought up today and concerns were actually part of site plan discussion at the time. Without having that luxury to go through site plan, that is why I'm assuming that we're doing this process first. Exelon's process did go to the EFSB in large part because of potential appeals of the ultimate planning board approvals. But yes, so to the context, yeah, there is a difference in the zoning piece, and we were not at that point where we could actually conduct any type of rezoning to present it to the residents, and then ultimately go to the planning board for local jurisdiction first.
For the time being, Mr. Shea, I'm done with my questions.
Does the company have any questions for Mr. Boynton?
Can you give us just one moment?
Yes, of course. Let's go off the record for a minute.
The company has no questions. Thank you.
That was not on the record, just so it's clear.
Let's go back on the record.
The company has no questions. Thank you very much.
Okay, company has no questions. Mr. Kaler, do you have any questions for Mr. Boynton?
No, I do not. Thank you.
Mr. Wong, do you have any further questions?
Yeah, just one question, and it's gonna be a record request instead of a hearing question, if that's okay, Mr. Shea.
Okay,
Mr. Boynton, again, this morning, I think my first question was about the public comments and the nature to that. I completely appreciate that you weren't able to testify today on that. So I'm wondering if you could be able to just give a brief description of those comments in the form of a record request. This will give you a couple more days to pull something together, and it doesn't have to be comprehensive, just something slightly more than what you testified to this morning, if that's okay.
I'm happy if it makes sense for you. I'm happy to actually print out the or share the emails that we received from the residents that did submit public comment.
That would work for me too, if the record request.
I'm sorry. Do you want a qualitative, do you want, in addition to a production of all the comments, the written comments that were received, do you want any kind of qualitative response from Mr. Boynton as to how those comments, if at all, were incorporated or referenced in the final HCA?
I'll ask one question before I make an answer to that. Mr. Boynton, how many comments did you get like that?
Less than, say, we probably had about 6 emails.
6 emails?
That's just about a guess.
Okay. Then I would say the first part of the question, my record request would be I want a copy of those emails. And then Mr. Boynton, I guess the other follow-up question would be, you had testified that you didn't think that the emails came up to any substantive changes in the HCA. I don't know if a qualitative answer from you in writing would be any different. So I hesitate to think that I want to ask that if that's, so I think, but let's make it a 2-part question. So the first part would be,
Mr. If I may,
yeah.
Mr. Shea, I truly apologize, but I need to take another break.
Okay.
oh, sure, let's take a break. We would normally take a break around this time, so let's take a 10-minute break.
Can I ask?
I'm sorry, are we on the record?
Yes, stay on the record.
Off the record for a second.
All right. Go off the record.
Are there going to be other questions from anybody? Because I can use this break when Mr. Boynton is available to discuss whether there's any other redirect for him.
You can use this quite well. Let me ask Wayne, Mr. Wong.
It doesn't seem like there's going to be more. I'm not sure if Andy or Joan would, but they're not here. So I don't think we should take that into consideration. So.
So, Mr. Bernstein, do you want a substantive break so that you can talk to your client about redirect?
Yeah, unless somebody else is expecting to ask any additional questions, because I don't want to obviously do it until everybody's finished. I understand where this record request might be going, but that won't impact whether we do any redirect.
How much time do you want, Mr. Bernstein?
Just another 5 minutes on top of the 10 that you already
Okay. So let's adjourn for 15 minutes. Well, it's 11:10. I'll see you back here at 11:25. So let's go on the record. Mr. Bernstein has requested that he have some time to confer with his client regarding redirect. So we're going to take a 15-minute break. It's 11:11 according to my phone. So I'll see you back here at 11:26. Thank you very much. Okay, we're off the record. Mr. Bernstein, did you have a chance to talk to your client?
I did. Thank you very much. I believe after the record request is concluded, I have a couple of brief questions on redirect.
Very good. All right, let's resume on the record. Okay, we're resuming. Mr. Wong, you were asking some questions. Please continue.
Thank you, Mr. Shea. Before the break, I was formulating a record request for public comments that the town got on the preliminary HCA, which was published, I believe, last year. I would like the town to provide a copy of the comments that it had received from the public on the HCA, and also a qualitative description, if there are any to be had, about any changes that that came about from the comments substantively to the HCA.
Mr. Lockwood, happy to do that. I have, while I was on break, actually looked it up. I have 5 emails on comments, one from Mr. Yorkis, one from Mr. Charlie Myers, one from an Anselin Wolf, one from a Thomas Carson, and one from a Mike Henry, and I will produce those for you.
Thank you.
And you already, I believe you already have the planning board's letter.
Yeah, if you could provide them all together,
Sure, happy to do
that
that.
would be helpful too. Thank you.
Just a second, go off the record. And Mr. Brock, what number would this be? Oh, Alan, you're muted.
Let me look at the previous transcript.
Sure.
Mr. Wang, while Mr. Brock is looking at that, would you, I was able to attend some public meetings, not hearings, meetings of the select board. And there were discussions during those meetings from members of the public, which also may be valuable.
I think that could be valuable, Mr. Shea. I'm not sure about the legal sort of. I don't know how this goes about, because I guess we don't have a sponsor witness. But how does that work?
If you wanted to ask a record request to get a copy of the hearing transcripts, that would be fine. The only problem would be what days of hearing transcripts would you want? I mean, I'm sorry, the siting board meeting transcripts, if there are any, I don't know. And you'd probably have to look for specific days.
You mean select board meeting?
Select board.
Select board, excuse me. Why don't we go on? Why don't we go on the record? But first, Alan, tell me what the record request number is.
The next one will be 6.
6. Okay. So record request
I'm sorry, are we on the record?
Yes, go back on the record. Excuse me. RR-EFSB-6. Okay, Mr. Wong has asked that question. It's characterized as RR-EFSB-6. And I believe, Mr. Boynton, you said you wouldn't have a problem producing those documents.
No, and in fact, following up on that point that Mr. Yorkis made, we could certainly get you copies of the meeting minutes of the select board, and we'll get you copies, just so that there's open transparency. We'll get you everything from July 1st of last year through the end of August, when this was presented to the select board.
Thank you, Mr. Boynton. Mr. Yorkis, Dr. Yorkis, sorry. Does that sound like?
That's great. That's
yeah,
great. Thank you.
Thank you.
Thank you, Mr. Boynton.
That's very helpful. Thank you, Mr. Boynton.
Well, I'd do anything for you, you know that.
I do.
I see that Mr. Green and Miss Foster Evans are back. I'm not sure if they did have any questions for the town pre-prepared.
Mr. Green, do you have any questions for Mr. Boynton?
Not at this time. Thank you.
Okay, thank you. Ms. Foster Evans, do you have any questions for Mr. Boynton?
I do not at this time, thank you.
All right. Mr. Bernstein, well, I should ask, Mr. Kaler, I don't believe you have any more questions?
That's right, Mr. Shea. No, thank you.
Okay, Mr. Kaplan, do you have any questions?
We do not.
Thank you. Mr. Bernstein, when we were on break, you expressed a desire to do redirect. Would you like to begin your redirect now?
Yes, thank you very much, Mr. Shea. I have two lines of redirect. Do you recall, Mr. Boynton, earlier this morning, there were some questions directed to you about the language in the host community agreement, talking about a tax agreement, or I think you may have referred to it, or the question may have referred to a pilot agreement. Do you recall that
I do.
discussion? Can you explain whether a pilot agreement and a tax agreement are one and the same thing?
There are some technical differences, perhaps, but essentially they are the same. They establish a long-term, and in this case, it would likely be a 20-year tax commitment on the part of the taxpayer to the town of Medway. So there are some technical differences, and we would utilize the most appropriate agreement to comply with the law. So if a pilot, if you will, is what we did with Exelon. If it works here, we'd use it. If not, we would do a whatever agreement mechanism works most closely with the law.
So they're both long-term agreements, is that correct?
That is correct.
Okay, thank you. Do you recall a little bit later this morning, some questions from Mr. Yorkis about the decommissioning bond?
I do, yes.
And you recall some questions about how the amount of that bond was established?
I do.
Okay, can you explain what the purpose of the minimum of the bond amount is intended to be?
Well, much like we discussed, it was establishing what at a minimum the company would be responsible for in terms of actual surety, so protections to the town, if you will, for removal of property or equipment from the site. If the cost exceeds $15 million, it doesn't eliminate the responsibility, at least in our interpretation from the company, but it just simply caps the cost, caps the surety at 15 million, and then whatever, again, the expectation would be whatever the cost is or above that would still be the responsibility of the company.
When you say surety, you mean a formal bond, is that correct?
Correct.
That concludes my redirect, Mr. Shea. Thank you very much.
Thank you. Unless we have any other questions, we'll excuse Mr. Boynton. Thank you for your testimony, Mr. Boynton.
Thank you, folks. Have a great day. Thank you for the process.
Thank you. Okay, it's 11:30. The other questions for the day were consistency with the policies of the Commonwealth and zoning. Mr. Kaplan, do you have the witnesses available for those questions?
That would be Mr. Lyons and Mr. Adams.
Mr. Shea, if I could, before those questions start, because I'm going to absent myself, and I just want to ask, I can be on the record, when you conclude the hearings, do you intend that the company or the siting board will move all of the exhibits, or do you want me to be present on Wednesday, which I believe would be the last day for any of that or the cleanup items?
Our procedure is that on the last day of hearings, we move to admit all evidence marked for identification, all items marked for identification into evidence. And at that time, people can object if they want, and we'll hear the objections. So it's up to you as to whether or not, do you think you'll have any objections to raise?
I don't think so. But I mean, I don't know. I guess I can check in with you by email if you, what you intend on Wednesday morning based on where you are in terms of cleanup. I don't mind being present, but
there's no guarantee that we'll go to Wednesday morning. If we finish today, then there would be no Wednesday morning.
Okay. I don't anticipate being available later today. I had only planned on the morning, so I will state that I have no objections to any of the other exhibits. And from the town's perspective, we would just want to move Mr. Boynton's pre-filed direct testimony and the 6 information responses
Into evidence.
into evidence. Yes.
Yeah. Yes. Thank you.
Okay. Thank you very much.
Thanks, Mr. Bernstein.
Okay, I'm going to leave. Thank you all.
Mr. Shea,
Yes, sir.
when we spoke last week, we talked about the pathways study, which you shared with everybody.
Pathway study, yes.
And well, I confess that I did not read the whole document. I read a substantial amount of it.
Yeah.
And because of that, I spent some time and identified one of the things I didn't find in that document was references to decommissioning.
Okay.
And I don't mean that as criticism. I simply mean by observation. And I was able to find 2 documents that were prepared by the Energy Storage Association. One entitled from April 22nd, 2020, entitled End of Life Management of Lithium Ion Energy Storage Systems, produced by the Energy Storage Association, and another document produced by the same entity called ESA Corporate Responsibility Initiative Guidelines for End of Life and Recycling of Ion Battery Energy Storage Systems. They're not 200 pages. They're a little over 20 pages each. And I really think I would like to figure out a way to have them on the record if that's possible.
Okay, so I think that what you want to do is you want to introduce these documents. We haven't seen them, but you want to introduce these documents into evidence. Why don't I ask Mr. Kaplan what his reaction is to that request?
So 2 things. I am familiar with both of those documents. They were considered as guides. They're not in any way statements on what decommissioning should be. So they're not completely, I mean, they're informational, but they're not really relevant to the negotiations, the specific negotiations that the company and the town had with respect to decommissioning. So whatever they say, first of all, it was done in 2020 and the negotiations were concluded in 2022. So there's difference in costs and recycling, and things have changed in those 2 years, fortunately. And so
What's the bottom line? So do you object or do you not object to introduction of those documents into evidence? Or do you want to wait and review the documents and then make your decision as to object or not to object?
I have no objection to including the documents. I would just suggest and respectfully request that they be given due weight, given that they are guides and not anything specific to this project.
Okay. I'd like to go off the record while I discuss one option. One option, I haven't seen the documents Mr. Yorkis refers to. Doesn't mean that they're not, obviously, they could be relevant. One of our options would be.
I'm sorry, are we still on the record?
No, off the record, excuse me. Off the record, yes. I haven't seen, all right, so just off the record to have a discussion. One of our options would be to admit the documents Mr. Yorkis wants to admit. Another, because there's no objection from Mr. Kaplan, another would be to ask Mr. Yorkis to send his documents to everybody later today when we get off the, when we conclude, and then make a ruling on them on Wednesday.
Are we going to meet on Wednesday?
What's that?
Are we going to meet on Wednesday?
Well, if that's what we decide to do with respect to your the documents you want, then that would be the time to do it. You could send them to all of us today, and then we'd read them on Tuesday, and we decide whether or not they're admissible. Or we could just admit them, or we could, out of hand reject them. That's not my inclination, because Mr. Kaplan didn't, it's not my inclination to just deny your motion, because Mr. Kaplan doesn't object, and he did say that they are guidance, so they are potentially relevant. But I'd like to,
I guess my other question is, as long as we're off the record,
yes,
relevant to what? I mean, is it relevant to the town and I don't know what it's relevant to. I don't have an objection to admitting the documents if you really want to read them. And if Dr. Yorkis thinks that it's important, but if they state that decommissioning should be higher or lower, it seems irrelevant to me. The HCA was a negotiated agreement between the company and the town. They came up with the decommissioning bond. That's a number that everybody agreed on. It really doesn't matter what the guidance is from the ESA from 2 years ago.
oh, I understand that, but I think that the argument you've just made, which is a good argument, really goes more to the weight rather than to the admissibility, especially in an administrative forum where there's just a remarkable range of admissible evidence.
I agree. That's why I didn't object. I think it goes to weight, not to.
Right, you don't object, but it may not be that relevant. Does our general counsel have an opinion?
General counsel always has an opinion. So it seems as if Mr. Kaplan doesn't object, you could let them in. You give them due weight. It seems that they may be the subject of argument on brief.
Yes.
And Mr. Yorkis would identify what's important about what he feels supports his argument on brief, and Mr. Kaplan has the opportunity to respond to that argument on brief. So it seems as if the both parties' rights would be well protected that way. That would be my initial take here.
Okay, that's fine. Mr. Green, do you have something you want to say? Guess not. Okay. That's right. Oh, okay. So why don't we, and just that, Mr. Kaplan, you would have to assign these documents and exhibit number.
Yes.
Before we go on,
would they be exhibit MEP 1 and
Whatever.
2?
They should be MEP exhibits because Mr. Yorkis is asking to admit them.
right?
Yes. So
Didn't the questions come in as exhibit MEP 1, 2, 3 up to 46, or were they given a
no,
different?
I think they came in as IR. So MEP 1 through 48, and this would be exhibit MEP. Well, however you want to do it, actually is.
Could be MEP 49 and 50.
Or we could do exhibit that, so they were IR, the answers to the information request were clearly answers to information requests. So I don't have the exhibit list in front of me, so I just don't want to make sure there's no confusion.
So it seems like, Bob, 49 and 50, they're unique numbers, even though the ones before that are IR responses, but 49 and 50 would allow you to cite to them without any confusion, right? That's the point.
I don't have any objection to that. Does that, Mr. Kaplan, Mr. Yorkis, is that acceptable to you? We'll designate them as NEP 49 and MEP 50.
I will send
Works for
them
me.
out, if that's all right with everybody. I'll send them out in 2 separate emails because of size.
Okay, that's fine. Thank you.
Thank
All
you very much.
Sure. So let's go back on the record. Mr. Yorkis has expressed a desire to submit for our review 2 documents that he wants to be exhibits in this proceeding. No one has raised an objection to his submitting these documents. We haven't seen them. So Mr. Kaplan has pointed out that by not raising an objection, he's not admitting that they are relevant or should be given much weight or any weight, but he's just not objecting to including these records including these exhibits in the record. So why don't I get on the record, Mr. Yerkes, why don't you describe the two exhibits on the record?
The two documents, the first one is published by the Energy Storage Association. It's dated April 22, 2020, and it is entitled Energy of Life Management of Lithium-Ion Energy Storage Systems. And the second document.
Okay, so that document will be marked as exhibit MEP-49.
Yep.
And tell us, the next document will be MEP-50, and tell us what the title of that is.
That is published by the Energy Storage Association, August 27th, 2020. And its title is ESA, Corporate Responsibility Initiative, Guidelines for End-of-Life and Recycling of Lithium-Ion Battery Energy Storage Systems.
Okay, so those will be admitted as exhibits MEP-49 and MEP-50. And Mr. Yerkes has promised to send us all a copy of these exhibits, preferably by the end of the day, but if that's problematic, tomorrow morning would be fine. Now, when you send these, please send them to the whole exhibit list, the whole service list, excuse me, including dep.efiling@mass.gov and
I'm sorry, DEP what?
at e-filing.
DPU.
I'm sorry,
DPU.
excuse me, D.P.U. Thank you, my mistake. D.P.U. at e-filing, one word, e-filing.gov. And also send them to our administrative assistant who coordinates all the filings, Janine, G-E-E-N-E-N .Bartley, B-A-R-T-L-E-Y @mass.gov. But those emails should be in the service list if you've got it.
I have that. Thank you.
Good. Okay. All right. So thank you very much, Mr. Yerkes, for agreeing to serve those. Thank you, Mr. Kaplan, for your response. And then what time do we have? It's 11:48. It's up, off the record. Would you like to break for lunch now, or would you like to go until 1 and then break for lunch? Mr. Kaplan, what's your opinion?
We can keep going here.
Okay. Mr. Kaler, do you have an opinion?
No, Mr. Shea, I don't.
Okay, so let's go back on the record. We will begin with the other two matters that are scheduled for today. First being consistency with the policies of the Commonwealth. I'd like to start that unless one of my colleagues has questions that they want to get in first. Okay, seeing that no colleague has asserted the desire to get in a question first. Let me ask the witnesses and for the company about some questions about qualified energy storage systems. The response to EFSB-CPC-6, attachment 2. I'll give you a chance to bring that up.
6.
Yes, EFSB-CPC.
I'm sorry, who asked that question?
That was Justin,
Thank you.
I guess.
This is Sam Lyons. I'll be able to answer this question. I am there.
I don't know why I'm having this trouble with my, having trouble off the record. I'm having trouble with my computer for a second. Here we go.
CPC 6. That's the guy.
attachment 2.
Okay, back on the record. The attachment to EFSB-CPC-6 is entitled Clean Peak Energy Portfolio Standard. Would the company attempt to qualify the project as a clean peak energy resource?
Yes, we will.
Okay, and who makes that determination?
We collectively have made the determination that this program provides incentives that are worth us pursuing.
Okay, but who makes the determination on the governmental level?
Oh, on the governmental level. DOER.
DOER, thank you. Would the project be qualified as a clean peak energy resource by virtue of its status as a qualified energy storage unit?
Yes, it will be.
Okay, I want to take a look at the relevant statute, which is quoted in this attachment. It's General Laws, Chapter 25A, Section 3. Now, let me read the definition of a clean peak resource and ask you then at the end if the project would fit that definition. Clean peak energy resource is a qualified RPS resource, a qualified energy storage system, or demand response resource that generates, dispatches, or discharges electricity to the electric distribution system during seasonal peak periods, or alternatively reduces load on said system. Would the project fit that definition?
The project is, I would have to, the part that I am thinking about is the discharge into the distribution system. Technically, the project is interconnected into the transmission system, but the energy is ultimately delivered to the distribution system.
Right. Part of the, I thought about that same issue as I read this. Part of the definition is alternatively reduces load on said system. So reduces load on the distribution system. I'd be happy to take that as a record request if you want. Just if you want to take a moment to think about it. Would
Yeah,
that be better?
I would also, sure, yes, we can do that. We can respond more fully once we've had a chance to look at the relevant statutes.
Okay.
And provide
So
a more comprehensive response.
Thank you. My question is whether the project would constitute a clean peak resource, which is defined in the regulations as a qualified RPS resource, a qualified energy storage system, or a demand response resource that generates, dispatches, or discharges electricity to the electric distribution system during seasonal peak loads, or alternatively reduces load on said system. So that's the question. I want to look now at the regulation that's quoted in the attachment 2, 225 CMR 21.05, which requires that the clean peak resource shall be interconnected with or offset load otherwise served by the distribution system or interconnected with the transmission system in the Commonwealth of Massachusetts. The clean peak resources must demonstrate that they generate, dispatch, or discharge electricity to the electric distribution system in Massachusetts. Would the project qualify under that definition?
Yes, since the project is interconnected with the transmission system within the boundaries of the Commonwealth of Massachusetts, it would qualify under that definition
Okay,
for my reading.
thank you. The analysis that accompanies the petition at 66. Why don't I give you a moment to take a look at that? The analysis that accompanies the petition, excuse me, at 66.
The analysis of page 66.
I just note that we did not make a new record request.
Oh, beg your pardon. Let's go back on the record. That record request regarding Clean Peak Resources,
I have it here, but
RR-EFSB-7. Thank you, Mr. Rob.
I'm there. I'm there.
Okay, thank you. The analysis of 66 strongly implies, but doesn't explicitly state that the project would constitute, a quote, qualified energy storage system. But would you agree with that assessment?
The assessment that it does not state that the project is a qualified energy storage system.
Right, but you've said previously, as we testified, that I believe you said when you testified that it would be qualified as an qualified energy storage system.
Let me just read a little bit here. So I would state two things. We have said in a couple of places, the first sentence, that the project is consistent with the Massachusetts Clean Peak Standard. We also say the project is uniquely positioned to satisfy the CPS, but I will note that ultimately the DUER has the responsibility to qualify projects as eligible resources under CPS.
Okay, that's helpful. I want to look at the Clean Peak Energy Portfolio Standard Regulations, which are at 225 CMR 21.02. These list a few requirements for an entity to be qualified to be considered as a qualified energy storage system. I'll let you get to those. I'm going to take a moment to get to those.
So what is this attachment 3? CPC 6 attachment 3, the 225 CMR 21-00.
Yep.
Okay, I'm there.
All right, three of these requirements are of particular interest to me. One requirement is that a qualified energy storage system must operate primarily to store and discharge renewable energy. All right. Now that part of the definition relates to one particular criticism of the project that I've heard, which is, how does the company ensure that the energy that the project stores would be primarily provided by renewables? Do you have a way to address that concern?
Sure. The regulation And so the regulation, the program provides for a certain charging windows. I'll refer you to the regulations at 21.05 number 2, qualified energy storage systems, and there's a table there that denotes certain windows of time during which the DOER has determined that the project is charging using renewable energy. These are the wind-based charging hours and solar-based charging hours. And it is the DOER who has determined that projects that charge during those windows will be deemed to have charged their systems with renewable energy.
Thank you. Could you give me the site again to that?
Sure. It's 21.05 eligibility criteria for clean peak resources.
Okay.
And it's parens 1 number 2.
Thank you.
And parens 1 and Romanet C, or not Romanet, but C.
Thank you. Now, I think the response to MEP-39 raised the issue of whether Medway Grid had energy to supply agreements with dedicated renewable energy resources. And I'm going to ask, and I believe Medway Grid does not have such energy supply agreements. Is that relevant or not?
We do not have dedicated renewable energy supply agreements. That is one option for projects to qualify as a QESS. I will refer you to B within that same citation I earlier noted. B is contractual pairing with a qualified RPS resource. So that is one option to qualify. Another is C, which is charging during the hours as specified there. So there are two, there are as one of, it looks like 4 different ways to qualify as a QESS. But we have opted to stay within those charging windows in order to qualify.
Thank you. Looking at 225 CMR 21.02, it states that an entity that seeks to be a qualified energy storage system must be, quote, an energy storage system as defined in section 1 of chapter 164. Do you see that?
Yes, I do.
Okay, so I want to go over the issue of whether the project would qualify as an quote energy storage system as defined by section 1 of chapter 164. The section is long, so I'll break the section down to more easily understood fragments. Okay, general laws chapter 164 section 1 defines an energy storage system as, quote, a commercially available technology that is capable of absorbing energy, storing it for a period of time, and thereafter dispatching the energy, which may be owned by an electric distribution company. So let me ask you, based on that, is the Tesla pack to be used by the BESS commercially available?
Yes, it is.
So then the Tesla pack would qualify, do you believe the Tesla pack would qualify as commercially available technology?
In my opinion, it would.
Okay. The statute continues using the disjunctive, using or rather than and. Quote, provided, however, that an energy storage system shall, and then the next four requirements are in the disjunctive. 1, reduce the emission of greenhouse gas. 2, reduce the demand for peak electrical generation. 3, defer or substitute for an investment in generation, transmission, or distribution assets. And 4, improve the reliable operation of the electrical transmission or distribution grid. Now, could you tell me which, I'll be happy to repeat those if you don't, if this is too much, but can you tell me which?
Mr. Shea, I'm just giving the witness the language. I don't think it's in the record, so.
I'm sorry, do you want a
And when
moment?
you're talking about, so I'm looking at it, just a clarification. Is your assumption that these are an and or an or in between the 4 options here?
They are ors.
Sure, okay.
Okay. So do you want me to repeat the 4 ors?
No, I can see it.
Okay.
Let
me
so
just
it's
ask you-
reduce emissions of greenhouse gases.
Wait.
reduce
I'm sorry,
demand.
I can't hear you. What?
Let me ask you first,
Sure.
would the project reduce the emission of greenhouse gases?
Yes.
Would the project reduce demand for peak electrical generation?
Yes, it would.
Would the project defer or substitute for an investment in generation, transmission, or distribution assets?
Yes.
And by the way, with that, substitute for an investment in generation assets, is it fair to say that this project would substitute for investment in peaker facilities?
I think that's a fair, that's a fair assessment that the project could potentially displace existing peaking generation.
Thank you. And the final of these 4 is, would the project improve the reliable operation of the electrical transmission or distribution grid?
Yes, it would.
Chapter 164, Section 1 continues by listing 4 requirements using or rather than and. One is project could use mechanical, chemical, or thermal processes to store energy that was generated for use at a later time. Is that something the project can do?
Yes.
Okay. Number 2, subsection 2, would the project store thermal energy for direct heating or cooling use at a later time in a manner that avoids the need to use electricity at that later time?
No, that is not a system that this, or that is not a process that this system utilizes.
Okay. Number 3, would the project use mechanical, chemical, or thermal processes to store energy generated from renewable resources for use at a later time?
Yes, it can do that.
Okay. 4, would the project use mechanical, chemical, or thermal processes to capture or harness waste electricity and to store the waste electricity generated from mechanical processes for delivery at a later time?
I would need to understand the definition of waste energy generated from mechanical processes. I'm not sure.
Well, this is Jason Yannick. The answer is no. Okay. I believe that is referring to a combined cycle facility or a cogeneration facility.
Okay.
They use waste heat.
That seems logical. Okay. All right. So that was no. Another requirement under the regulation 225 CMR 21.02 is that energy that seeks to be a qualified energy storage system,
I'm sorry, is that a what?
An entity that seeks to be a qualified energy storage system must, quote, receive a statement of qualification from the Department of Energy Resources. Now, according to the response to EFSB-CPC-8, the company has not yet submitted a statement of qualification to DOER. That was as of December 28th, 2022. my question is, has the company submitted such a statement of qualification application to the DOER as of today?
No, we have not.
When do you expect, if you can, when do you expect to submit a statement of qualification?
I don't have a firm date on our schedule when we expect to do that. Certainly, certainly well before we are operational, but I don't have a firm date in our schedule when we expect to do that.
And if you can't answer this, that's fine, but do you think that you might submit such a statement of qualification by, let's say, May of this year?
I think it's unlikely.
Okay.
I think we would do it later than that.
Okay, thank you. I'm off the qualified energy storage system questions. Moving on to some other consistency questions.
Mr. Shea,
Yes.
before you move on to a different topic, could I just ask a follow-up question to ones that you've been?
Please do.
Okay, thank you. So the discussion that just happened seems to suggest that if the company meets the provisions of the Clean Peak program and charges the battery at certain hours and discharges at other hours, that almost, by definition, it will be presumed to be storing clean or renewable energy resources and displacing presumably more emitting, higher emitting generation when the battery is providing energy to the grid. Is that correct?
Yes, that's correct.
So there are two pieces of it. One is what's assumed to be going essentially into the battery, and then what it's displacing on when dispatched. Is that fair?
Yes, I think that's fair.
Okay. So I think we've established that there's no energy source that is directly paired with this battery, so that we know intuitively what is actually going into the battery as the primary energy that's being generated, correct?
Yes, that's correct. The project will be charging from the grid, and it will reflect the grid mix at the time that it charges.
And again, just to refresh my understanding, what are the hours that the battery would be able to charge to qualify under the Clean Peak provisions?
Yeah, Yes. So the charging hours can be found in a table in that citation I previously provided, 21.05 parens 1 number 2. In all, there are 4 different seasons where the hours shift slightly. During all seasons, 12 a.m. to 6 a.m. are considered wind-based charging hours. And then during the spring, there are seasonally changing solar-based charging hours. In the spring, that's 8 a.m. to 4 p.m. The summer, it's 7 a.m. to 2 p.m. Fall, it's 9 a.m. to 3 p.m. And winter, it's 10 a.m. to 3 p.m. All of those hours are considered solar-based charging hours.
Is there any requirement that Medway Grid or any other participant in Clean Peak has to have any kind of contractual linkage to a renewable energy source in the form of RECs or other purchase relationships?
No, that is establishing a contractual pairing with an RPS resource is one option. That is B under that previous citation. It can choose to do that, or it can choose to utilize the charging windows that have been provided in the table.
So can you offer an explanation or some insight into why you think the Department of Energy Resources selected those particular hours as the charging window to establish the nexus between renewable energy sources and what's going into the battery?
I can't speak to all of the I can't speak to everything that went into DOER's selection of those hours. I was not close enough to the process to understand all of the considerations that went into that.
Perhaps we could make that a record request then, for the company to provide an explanation, perhaps based on DOER's rulemakings and regulatory documents, as to what the nexus is between charging in those specified hours and establishing that renewable energy is what's being used to recharge batteries participating in the Clean Peak program.
Okay, do you understand that question?
If you can just give us one moment, we think we might actually, Jason, I think, has a response.
This is Jason Yetnak. I'm looking at the CPS standard down on page.
I'm sorry, I can't hear you.
I'm looking at the CPS eligibility guidelines that we've been referring to. Going down to the next page. Under determinations, there's the fourth paragraph explains the reasoning for those hours. And it says, charging qualified energy storage systems when renewables are at the highest percent of the generation mix and discharging during peak ensures that these systems are shifting renewable energy. Eligibility of qualified energy storage by charging coincident.
I'm sorry, eligibility what?
Eligibility of qualified energy storage by charging coincident with periods of typically high renewable generation will be determined by self-certification by the applicant when requesting a statement of qualification. I think this answers those hours, is that these are the typical periods when there is either high solar or high wind. And that is how, in my opinion, they based the eligibility for the charging coincident periods.
That's very helpful. Thank you for pointing that out. I think even that information gets to some of what I'm after, but maybe doesn't totally resolve the concern. Are you familiar with the notion of a marginal resource on the grid at a particular point in time?
Yes.
Can you give me a working definition of what that means?
You want to go for it? You want
to? Sure. I will give my own definition and my professional experience. A marginal resource on the grid is the resource that sets the locational marginal price at any given point in the, at least on the transmission system.
And would that have anything to do with the fact that given, let's say, an increase in a megawatt hour demand or a decrease in a megawatt hour of demand at a certain location and a certain time, the marginal resource would be the one presumed to fluctuate with those changes in demand?
I think that's accurate. The marginal resource is the next resource that would be turned on given an increase in demand.
And is the concept of a marginal resource synonymous with, or at least associated with, the concept of dispatchability? In other words, to meet additional demand, the resource has to be dispatchable so that it can be activated when needed or curtailed when it's not needed.
I'm not sure I know the answer to that one, whether or not a resource must be dispatchable in order to be considered a marginal resource.
Mr. Yednak,
I'll
did you
agree
have a response?
Yeah, so I'll agree with that statement. Yeah, I think dispatchability is resources that tend to be on the margin happen to be more dispatchable, but that's not always the case.
Could you?
And it doesn't have to be the case.
Could you describe, let's say, the exception to that general premise?
I guess I could offer an example that for instance, in northern New York overnight, you may have wind resources that are on the margin as they have submitted bids that in an economic merit order would be selected above other units for any subsequent increase in demand. That would be one real life example, but my understanding is that a project does not need to be dispatchable in order to be marginal. It merely needs to have a bid that would be the next, that would be selected given economic merit order as ISO New England is setting the prices to balance supply and demand at any given point.
And when renewable resources like solar or wind are bidding into ISO energy markets or perhaps even ancillary service markets, do their bids tend to reflect the variable cost of producing energy in those forms?
I can't really speak with too much authority on the bidding behaviors of wind and solar assets, except given just some observations as I provided there. So I'd have to think about that, but I can't answer that at the moment.
Well, on a cold winter night when, let's say, the ISO clearing price might be, $300 a megawatt hour, can a wind generator bid into the forward capacity? I'm sorry, the day ahead energy market at the assumed $300 per megawatt hour price? Is that permissible under ISO's market operations?
Yes, it is absolutely permissible. Renewable resources, any resource, whether or not it is dispatchable, can bid into the day ahead or real-time energy markets, and they are responsible for either delivering that energy or covering that energy. And by covering, that means if you bid in clear into the day ahead, you either need to deliver that energy physically or buy out of that position in the real-time market, if I'm explaining that in a way that makes sense.
I was under the impression that ISO tends to require any bidder in its energy markets to establish that the price being bid has to have some connection to actual cost, whether that's fuel or operational costs, but that the bid cannot simply be designed to extract, sort of maximum value given the scarcity of energy at a particular time.
I'm afraid I just don't have enough information on how they establish, how they establish what prices generators are allowed to bid into the day ahead or real time markets.
So you mentioned the example of New York ISO and how perhaps on a winter evening, wind energy might be at the margin. Is that right?
That's correct.
Can you give us a similar example from your experience in the New England market where either solar, wind, or any other renewable energy source has actually been shown to be a marginal resource?
I don't have any specific examples in Massachusetts. Yeah, I'm sorry, I don't have a relevant example for ISO New England or Massachusetts specifically.
If I'm not mistaken, I believe ISO periodically puts out a report that analyzes marginal resources that have occurred in recent times. Is that right?
I believe that's correct.
Could I make a record request for the most recent ISO marginal marginal resource information? I'm sorry if that's not the exact name of the report, but I've seen it in the past, and it basically is an ISO analysis of what resources are at the margin in a certain period of time in the, again, recent past, last year or seasonally. Could we make that a request and have that supplied?
Okay, that would be record request RR-EFSB-8. I should just say, Mr. Green, that earlier you had started to do a record request, excuse me. And I believe that to a certain extent your questions were answered. So this is the only record request from you that I've got on the record for this.
Yeah, you're right. You're right. The earlier one that I was asking seemed to have been answered by the witness.
Okay.
Hypothesizing that the ISO marginal energy resource report that I just asked for shows that in no hours of the day or night or at any time during the year are renewable resources at the margin in New England. If that were the case, and accepting that as a premise, would the storage of energy by Medway Grid correspond to the notion of renewable energy actually going into the battery?
I would say specifically per the CPS regulations, it would still qualify under those hours. I think it is a matter of debate whether marginal versus average or marginal, I would say marginal versus a sort of grid mix focused philosophy on attributing an emissions profile to the project should be used, but per CPS, they would still be eligible in that hypothetical case.
Yeah, I think you put your finger on it perfectly just there in terms of thinking of whether we're talking about marginal energy sources or an average of some mix of energy in a particular time of battery charging. Fair to say?
Yeah, I think that's fair. I think at any given point, does our storage system constitute a marginal request to charge, or were we first in line? And how do you attribute a specific generator to a load? I think that's a complicated question because once the electrons enter the grid, they're all the same. So I believe it is a matter of debate, sort of generally or academically.
To the extent that one does take the viewpoint that the marginal energy sources do matter for truly establishing what the environmental benefits are of energy storage and discharge, would you agree that using average sources in the mix for recharging constitutes perhaps a oversimplification and somewhat of an erroneous representation of what those emission benefits really are?
I guess in my opinion, I would say that the emissions benefits of energy storage are better represented by thinking holistically about the generation profile of the system at an, I'll call it an off-peak time. So whether it's these wind-based or solar-based charging hours, and the increased emissions profile of the grid at the peak windows. And the Clean Peaks program was designed in order to accomplish that very goal. Within the underlying reason for the Clean Peak program included an assumption, or not, I won't say an assumption, included an analysis of the differing emissions profiles of those 2 times of the day, as well as really a long-term view of the future of how that will change and evolve over time to be even more, even to have a larger differential over time as additional renewable resources continue to penetrate deeper and deeper into the energy mix of the grid. So I understand your question about the emissions profile of any given project. And I guess my way of answering would be to look at the big picture that DOER and many others considered in the State of Charge report, which paved the way for a variety of different programs to incentivize energy storage by recognizing that single fact of the differential in emissions profiles of those 2 times, and seeking to displace the dirtiest generators, the oil-fired type generators, the diesel units that needed to be called upon during those evening peak hours. So I think there's a difference between attributing emissions to a specific project and thinking about the system on the whole, is how I would answer that.
So again, the company is not using the New England GIS system as it exists today in any way to sort of track what electrons are being stored in the battery and assumed to offset emissions when discharged. Is that right?
No, we are not tracking any emissions through NEPOOL GIS. NEPOOL GIS is the platform that the Clean Peak energy credits are traded on. So we will be utilizing it for that purpose, but not for tracking air emissions.
Can you explain actually how you will be using the NEPOOL GIS?
Sure. NEPOOL GIS is sort of I'll call it the IT backbone that is used for the minting and tracking of a wide variety of credits, including SRECs, alternative energy credits, and a variety of other credits. So Massachusetts is utilizing that same system to track the minting and the trading of those, and ultimately tracking compliance under CPS by the load serving entities for the Clean Peak certificates that are generated.
So what type of certificate would Medway Grid receive that it needs to have available to serve some type of compliance market?
That would be a CPEC, a Clean Peak Energy Credit. All load serving entities in the Commonwealth have certain compliance targets that are detailed in the regulations. Every year they have to meet increasingly larger percentages of their total load served, or I should say total energy delivered to load. A certain percentage of the total megawatt hours of energy delivered must be matched, I'll say, with a Clean Peak energy credit. And so we would be generating credits to be put into that market and ultimately transacted with those load serving entities to help them meet their compliance requirements.
So you mentioned a few things that are interesting. You said that the NEPOOL GIS is an information essentially backbone and that it's minting certificates. And I'm wondering, what information would the NEPOOL GIS be minting, including in the minting process for a Medway grid certificate?
Again, NEPOOL GIS is sort of the IT system, but the Clean Peak Energy credits that Medway grid would be claiming would be reviewed and ultimately certified. I'd have to figure out exactly I'd have to look and see exactly which entity within the state does that. I believe it's some entity under DOER, but I believe it's spelled out in the regulations and the guidelines. But the CPECs generated by Medway Grid would be certified as minted under NEPOOL GIS, and then on that system, the trading would be reflected, I guess, for lack of a better term.
So would you expect the sort of primary bits of information included in one of your certificates would be the time of charging and the time of discharging?
That's been, I think that is something that I won't opine on what I think the system is doing right now. I know that the Clean Peak standard is up and running. The specific accounting of the charging and discharging hours is something that is contemplated by the regulations, but is not overly prescriptive. And we look forward to learning more about exactly how that's being implemented, but in the system today. But again, I will say that the system is up and running. There are qualified resources that are generating CPECs right now. And the details of that accounting system are something, we will be closely watching and paying attention to as we qualify or as we register and under that system and are qualified.
Are there rules that exist right now in terms of what NEPOOL GIS is going to record for battery energy storage facilities?
I'm not sure I totally understand the question. Are there rules? Sorry, can you maybe clarify the question?
Again, I'm looking for the parameters of information that NEPOOL GIS is going to collect for the operation of a facility like Medway Grid. What do you expect that they will want to know about the operation of your facility to create a certificate?
Yes, I don't have that information on hand. We could certainly look through the regulations to give you some of that information that's reflected there. But I don't have any more detailed information than what's reflected in the regulations, given that we haven't gone through the qualification process as of yet.
Okay. Well, why don't we make that a specific record request then? And again, just to restate it, I'm interested in knowing what parameters, what data types NEPOOL GIS will collect or need to know about from Medway Grid to record your operations in their system.
Okay, that would be record request RR-EFSB-9.
Thank you. I think that concludes my questions, Mr. Shea.
Thank you so much. This might be a place that would be a natural breaking point for lunch. It's only 12:40. We usually break at 1, but Mr. Kaplan, would you like to break at lunch now, or would you like me to do another 20 minutes of questioning?
Up to you, sir.
Why don't, this is a natural breaking point. Why don't we break now? It's 12:40. Why don't I see you back here at 1:40? Okay, thank you very much.
Okay, thank you.
think it's.
I'll be right with you. Okay, is everyone set? Can we get back on? Should we go back on the record?
Yeah, it's okay by us. Sorry.
I don't know if Joan is ready or not. John, I saw you earlier. Okay, I wasn't sure if you were ready. Let's go back on the record. We are resuming this evidentiary hearing after lunch. Now, let's direct your attention to the response to EFSB-CPC-1. Let me know when you get there.
This is Sam. I'm there.
Thank you, Sam. The response to CPC-1 says the general but affirmative requirement for the board to promote environmental justice in a manner consistent with its mission that the Supreme Judicial Court recognized in the Green Roots case is a legal burden that falls solely on the board. Now that's interesting. So is there no responsibility for the company to engage in environmental justice?
We don't believe broadly that we have no responsibility in a general sense to
Sorry,
promote.
wait, there's a double negative. There's a double negative in that answer. We
Sorry.
don't believe broadly that we have no.
Yeah, sorry about that. I'll put that as an affirmative. We do believe that we have a responsibility to promote environmental justice. The case reads its own way, as we noted here, that specific case put that burden upon the board, but we believe that we do have a responsibility to further the goals of environmental justice.
Okay, thank you. Now, the company, in its answer to CPC-1, the company asserted that it provided translation services, quote, if required during the informational meetings that the company held. Were members, my question is, were members of the public informed that the translation services were available for these informational meetings?
Yes, it was in the EFSB notice.
Well, it's in the EFSB notice for the public comment hearing, but I understand that there were informational meetings separate and apart from the EFSB public comment hearing.
We did discuss that with the town, and the town determined that there was not a need for translation services during those information sessions.
Okay. All right, thank you. Now let's go to EFSB-CPC-3.
Okay, I'm there.
Thank you. The answer states that the BESS system can operate over a wider temperature range than peaking units without a reduction in output, and that it can respond more quickly to control signals. That's interesting. I just wonder if you could expand upon that a bit.
Sure. This is Jason Yennak. Could you repeat the question, please?
In the response to CPC-3, EFSB-CPC-3, the answer there states that BESS can operate over a wider temperature range than peaking units without a reduction in output, and that the BESS can respond more quickly to control signals. I just would like you to expand upon that.
Sure. Regarding temperature, first, there is no reduction in the output of our facility up to 50 degrees C.
50 degrees centigrade.
Correct.
And what is that in Fahrenheit?
Regarding 114 degrees.
Okay.
122, sorry, 122 degrees Fahrenheit.
Thank you. So go ahead, please.
The second part of that was on the ramping capabilities. The energy storage systems can respond in under a second. So in the millisecond range from zero output to full output. So they have a very extreme fast ramping capabilities that are very beneficial.
I'm sorry, they have very extreme what?
Ramping capabilities that are beneficial for frequency response on the grid.
That's helpful. Is that anywhere in the record that you're aware of?
Yes.
Okay, tell me
You can
where
provide
it's
the reference in just 1 minute.
Sure.
So I'm pretty sure. Mr. Shea, if you just give us one moment, we're looking through the record. I believe it's in the analysis and in the SEIR, but we're just checking.
Thank you.
Okay, I found the reference. This is Jason Yennak. I am looking at EFSB CPC 5 friend 1. This is the Massachusetts Energy Storage Initiative study. And I'm on chapter 8, section 8.1, page 173.
This is really impressive. tell me what it says on page 173.
We can pull it up if you like.
I can share on the screen.
That'd be helpful, thanks.
Just 1 second. Page first paragraph. So again, we are looking at CPC-5, Friends 1.
Right,
First full paragraph on the page says, across the country, advanced storage has been seen as an ideal technology to provide frequency regulation because it is the only technology that can adjust its full megawatt output in less than 1 second.
okay, and this is the state of charge issued, report issued by the Massachusetts Energy Storage Initiative Study. Is that correct?
Yes.
It's document number EFSB-CPC-5, Pren 1. That's helpful. That relates to the responsiveness, which is helpful. Do you know if it's if there's any place in the record that talks about the wider temperature range? As you said, the facility can there's no reduction in what the facility can output up to 50 degrees centigrade. Is that any place in this record that you're aware of?
Yes, and we can pull that up in a minute. It is the Megapack Excel datasheet. We'll find the reference.
Thank you.
This is Jason Yanak. One correction, we did not submit the data sheet. However, it is publicly available, and so per the manufacturer specifications for the Megapack 2 XL, the operating ambient temperature range is -30°C to +50°C. Again, that's on Fahrenheit, that is -22°F to 122°F.
Okay, and you say that's in the Tesla manufacturer's information?
Correct.
Do you have a URL where I could get that?
We can provide that.
Okay,
If
if you
you'd
don't
like to
have
do
it
that
right-
as a record request, we can do that.
Okay, so record request RR-EFSB-10 would be the URL to the Tesla manufacturer's information that you just quoted. Now that would be helpful to get. Going to EFSB-CPC-4, I don't fully understand the response. The question is, quote, whether completion and operation of the project would provide a necessary energy supply for the Commonwealth with a minimum impact on the environment at the lowest possible cost, close quote. The answer states that the project's successful clearing in the FCA 15 demonstrates the project is delivering capacity at the lowest possible cost relative to system needs. And here comes the words that I'm particularly interested in. Without the consumption of water resources or emissions of gases or solid waste to generate that capacity. And my question is, how does the project successfully clearing in FCA 15 lead to a finding that project will deliver capacity without the consumption of water resources or the emissions of gases or solid waste.
Yeah. Yeah, thanks for the question. This is Sam Lyons. I think the answer to that question was probably inartfully worded. We did not mean to tie consumption of natural resources to the FCA itself. We did not mean to tie those to the clearing and the auction. That was supposed to be a separate statement from the clearing and the auction with respect to the reliability of the system.
Thank you. I'll ask you to reference MEP-42 and I'll wait till you get there.
Yes, we're at MEP 42.
Okay, and in this information request, MEP quotes from the SEIR, which states that noise would be reduced by 1, using only 40% fan speed and limiting the number, and 2, limiting the number of active units during the midnight to 6 a.m. period. Can the project maximize the Commonwealth's ability to rely on renewable energy given these limitations? Or in other words, do these limitations inhibit the project from maximizing the Commonwealth's ability to rely on renewable energy?
No, they wouldn't.
Okay, tell me, explain that, please.
There's sufficient time over those nighttime hours, which coincide with the clean peak hours, for the system to recharge and be prepared for dispatching its power during another period.
So when you say limiting the number of active units during the midnight to 6 a.m. period, let me see if I understand this right. One unit might be active and it gets recharged, and then another unit would get recharged, and then a third unit like that. Is that roughly the meaning?
The meaning is that only 25% of the, oh wait, I'm sorry. Let me rethink this. The question is in regards to the 40% fan speed.
I'm thinking more about limiting the number of active units during the midnight fan period. Does that inhibit the Commonwealth's ability to rely upon renewable energy?
No, it doesn't. It just extends the amount of time it would take us to recharge. However, there's sufficient time over the nighttime hours to charge the entire facility.
Okay, so when the response talks about limiting the number of active units, even if at any one time the number of active units is limited, over the entire period, all the active units will be recharged. Is that correct?
Yeah. So this goes back to the noise analysis where they proposed just operating 25% of the plant at any given time throughout the night.
And I remember that testimony, and I think we had a few questions about it earlier. And I think that someone said it's this has to do with the Tesla battery pack is mass manufactured. So using 25% operating capacity, it's not like you're wasting the other 75%, but rather this battery pack is built so it could be in Western Australia and be under a harsh sun for quite a bit of time. Do you remember that?
Yes, I do.
Yeah, so it's by limiting the operating to 25%, it's not like it's not, correct me if I'm wrong, it's not like you're foregoing some opportunity to use renewables more, but rather you're just looking at the constraints on the system.
Yeah, I believe that's correct.
Okay. I'd like to direct your attention to the response to EFSB-G-2.
Mr. Shea, before you do that, may I ask a question?
Yes, go ahead, Mr. York.
Thank you. For clarification purposes only, is it 12 noon to 6 a.m. or is it midnight to 6 a.m.?
So the restricted, so that we would reduce the amount of plant that is operational over the nighttime hours. So it's midnight to 6 a.m. Yeah, the question was unclear to us because of the hours are 12 p.m. to 6 a.m.
Can we just?
So it's really midnight to 6 a.m.
I'm sorry, I didn't hear the question, Mr. Yorkis.
I'm sorry. So the quietest periods are from midnight to 6 a.m.
Sorry, can you please repeat? What's the question?
The way I'm reading this, it says 12 p.m., which is noon, to 6 a.m.
So, right, and the only time we would restrict the total number of batteries that can be used is during the nighttime hours, which is 10 p.m. to 6 a.m.
10 p.m.
That's consistent.
Okay.
Right.
So do you want to change this to reflect that?
Well, that would be your question. Sorry, that stated this 12 p.m. to 6 a.m. So I'm assuming that perhaps maybe the question had a typo that meant to say 12 a.m. to 6 a.m. Not sure.
I need to go back to, I just think it's important to clarify it. So if it's my error, I take full and complete responsibility for that error and would simply apologize to all parties and indicate that I think the goal, I think your commitment is from 10, if I heard you correctly, from 10 p.m. to 6 a.m. Is that correct?
That's right. That's where we would restrict the operation of the plant to 25% of its BESS units.
Thank you very much. I apologize for the error.
Thanks, Mr. Yorkis. Now, this, what we're looking at now, MEP 42, it quotes from EFSB-G-2. So I'll just ask you a question. So as I was looking at that, there's discussion of the clean peak energy certificates, which we've talked about earlier today. But there's also talk about obtaining revenue from having a clean peak energy certificate. Could you explain how the project would obtain revenue by having a CPEC?
Sure, this is Sam Lyons. So as we discussed before, the load serving entities in Massachusetts have a compliance obligation as a percentage of their total energy sales. And we are generating or minting CPECs, and we earn revenue by transacting either directly with load serving entities or through intermediaries to sell our CPECs to those load serving entities to allow them to meet their compliance obligations.
I see. So I'm sorry. So there's a market in that.
That's correct.
There's a market, I think, in that. I meant in the with the CPECs. All right, that's helpful. I want to refer to a report designated as EFSB-G-33-1. It was produced by ARUP US for the town of Medway.
Okay.
Here it is. Is there anyone who can? I know you don't have the person who wrote this report as a witness, but is there anyone who can answer questions regarding the report?
This report was prepared for the town of Medway,
Yes.
but we can do our best.
Okay, thanks. The report represents that one of the advantages of the BESS system is, quote, extremely high energy density. Could you explain that concept in layman's terms?
Sure, this is Jason Yedinak, and perhaps Sam could chime in on alternatives, but the amount of power, the amount of land that is required for what is a pretty immense amount of power is a multiple factor compared to other technologies. Can you chime in on like how much land we need comparable for a similar size?
I'm sorry, I can't understand you. I'm sorry, what?
I have Sam, my colleague Sam Lyons, compare to a solar facility and the amount of land required for a similar amount of capacity.
Sure. Yeah, I think the comparison we're making specifically is to other types of renewable energy resources with which we're most familiar. But for a solar array, for instance, batteries have the added dimension of having both a power component and a duration component. So there are two dimensions there. But broadly speaking, a solar array, in order to generate 250 megawatts, likely needs on the order of 1,000 acres, give or take 100 or 200. And we are putting our plant, I don't have the exact acreage.
About 5 acres.
5 acres. So, orders of magnitude, well, I don't know, however you want to say it, 5 versus, call it 1,000. So that when we refer to energy density, it is really it's really the power density, the ability to generate instantaneous power using a small amount of land.
That's helpful. We talked earlier, I think earlier today or yesterday, or last week, I asked about peaker generators, and the project can, to some extent, replace a peaker generator. Isn't that correct?
I would say in many instances it can, yes.
But and I know the answer to this, but I want to get it on the record. How do peaker plants in general fare with respect to emissions?
So what was the question? How do they what with respect to
How do
emissions?
they do? What's the comparison of peaker plants and their emissions, like say compared to your project, for example?
Peaker plants are generally considered to have the highest emission profile of many of the fossil plants that exist on the grid, specifically with respect to one of the largest resources in New England, natural gas. The peaking units can be fired with a mix of oil, diesel in cases, distillate fuel oil, and those are have the dirtiest emissions profile of the primary fossil resources in New England. Obviously, compared to ours, where we directly generate no emissions, there's not really a comparison. But yes, they are the dirtiest of the plants on the system.
So what would the effect on the air in Medway be if the project was where it's located, but it was a peaker rather than a battery energy storage system?
Send it to him.
Yeah, so I think AJ might be the best qualified to answer that.
All righty. Again, AJ Jablanowski, Epsilon Associates. A project of this size, you could reasonably take a look at the Exelon West Medway project as being a recent example of a modern, clean peaking project using fossil fuel. So the emissions that are listed in that proceeding, essentially scaled by the megawatts, the relative megawatt sizes of the projects, would end up being the emissions associated with a similar sized peaker project here. The question that I heard was specifically associated with air quality impacts. And when I hear air quality impacts, I think about actual impacts to the ambient air quality, what is getting breathed in a local community. And there would be an impact, but similar to that other proceeding, there would be an analysis to show that that impact is not above the relevant ambient air quality standards.
Okay, thank you. Now I'm going to refer you to another answer, EFSB-G-33 Wait till you get there. Wait till I get there.
Yeah, we're there.
Okay. In that answer, it says, quote, remote locations are considered those located more than 100 feet from all the following, which are defined as exposures. So the following are buildings, lot lines that can be built upon, public roads, stored combustible materials, and other exposure hazards. My question is, does the project's location qualify as a remote location? Is it 100 feet from all those entities?
No, it's not a remote location.
Okay, and tell me why not?
Because it's not 100 feet from the lot line or the public roads.
Okay. All right, thank you. That's the end of my consistencies with the policies of the Commonwealth questions. I should ask whether anyone else, first I'm going to ask people on the siting board staff if they have any other consistency questions. Yes, General Counsel.
I do have one question. It's not fully in the consistency bucket, but it's, I think, related somewhat to some of the things we've been discussing. And if we discussed this morning and I missed it, I apologize. We were discussing on Friday a little bit about some of the natural features of this particular piece of property, of this site. And we talked a little bit about the wetlands that are located there. We talked a little bit also about the impervious services and disturbed land that's already located on the site. And I think it was Mr. Bergeron who was talking about that. My question is, could you explain how the company accommodated the features, the physical features of this piece of property when laying out the battery facility, and how the company decided to put the battery facility where it did on that particular piece of property?
Yeah, this is Mr. Bergeron. I'll start and I'll let somebody from the company elaborate, but in my involvement on this project and working with the company to site this particular project on this site, one of the key considerations was avoidance of wetland resource areas. That was to try to locate the project such that it was outside of all wetland resource areas, including the 100-foot buffer zone, 2 vegetated wetlands, and a 200-foot riverfront area of Center Brook. So that was one consideration, and you'll see from the site layout that we attached with our attachment D in the SEIR document, which is exhibit NG6. You'll note that the best units themselves and the substation are on the western part of the property, and on the northern part of the property, closer to 109, to be outside of all of those wetland resource areas. In addition, we worked with the company to try to utilize existing disturbed areas such as the residential yard, and also the auto repair facility, as well as an area on the site that had already been previously cut in the past, so that it's not mature forest, it's more of an early successional community. It's taking advantage of all areas on the project site that were previously either developed or have had past actions on them. And I don't know if anyone from the company wants to add anything with regards to site topography and considerations of how they cited this on the project site.
No, I think what Mark has said is accurate. It was, he said the main goals of our siting process.
So as the company was designing the best layout, did the company consider other configurations within that piece of property for your best equipment and your substation?
This is Mark Bergeron. Yes, we did work with the company and had various alternate layouts for the project on the site, different stormwater management layouts and design, all working with the company to try to see if those particular alternatives would comply with wetland resource area jurisdiction and performance standards associated. My experience on this project is that some of the other iterations of layouts did not comply with, in particular, the 200-foot riverfront area performance standards. So again, changes were made to try to avoid those areas and comply with all applicable state and local standards for that resource area.
Was the town involved at all in the company's work to determine how the project would be laid out on this particular property?
This is Mark Bergeron. The town did comment on the expanded environmental notification form that we filed. They actually had a third-party reviewer analyze our ENF application. They provided multiple comments, in particular regarding stormwater management features and components of the system. And the company did work to address all of those concerns and comments regarding stormwater in particular in the SEIR. And so that's the most current design that you see in attachment D of exhibit MG6.
Jason Yanek, I will add that the fire department also provided comments on the road width and turnaround areas.
And did the company make any changes in response to those comments?
Yes, they did. In addition, as we're talking about this, snow removal, snow storage on the site was another comment from the town department, and parking spaces from the fire department. And those changes requested by the town were incorporated into the most current design that you see in attachment D of exhibit MG6.
Did the local residents have an opportunity to have any kind of input into the site design, especially the four houses across the street on 109 and that neighborhood that's on the other side of the is it Brook? I don't remember the name of the neighborhood, but the neighborhood's that's on the other side of the wetlands.
This is Mark Berger, and I'll start. Any resident in Medway would have had the opportunity to comment by reviewing the expanded ENF filing and the SEIR filing. Some residents did submit comments on those applications, not necessarily with regards to stormwater or some of the features we've been speaking about. I'll let Mr. Adams speak briefly about other opportunities outside of a regulatory permitting process that the public may have had to provide input.
In June of 2021, we went to each of the homes that abut the facility to invite them to an information session that we held. I think that was in June of 2021. And we offered them an opportunity to make comment on the plans, on the project in that session.
Did you receive any feedback during that session?
We received feedback, but I have to say that the feedback was not specific to the site layout. It was more us sharing information about the project, and there were questions, more curiosity on battery storage, and the scope of the project in particular.
Did you receive any feedback on the proximity of the project to those four houses across the street on Route 109?
Not from the residents. We have received comment from the town about that, about the proximity of the facility and the wall to the road.
And what kind of feedback did the town give on that, the proximity there?
They mainly focused on what the aesthetic of the wall would be, and then also what we would be doing to, I guess, quote, soften it, which would be our landscaping and, sort of beautification of our frontage.
Did you receive any comments from the town regarding just noise for those four properties that are across 109? My understanding is the wall is a noise mitigation wall. So I'm assuming that there is some noise that would reach those properties across the street without that wall.
Yeah, there is some noise, and we've documented that in our noise study. And we've shown that we would still comply with Mass DEP noise standards or noise policy. So yeah, the street is quite noisy. As we've talked about earlier today, it has quite a bit of traffic and a lot of influences going up and down that street throughout the day.
When you say you'll comply with the Mass DEP noise standard, is that with the wall?
That's correct.
Okay. And the town.
The noise wall would essentially prevent any transmission of noise through it. So it would knock down our noise profile by the necessary amount to comply with the policy.
And the town asked for some landscaping in front of the wall. Is that what I heard you say?
That's correct.
Pardon me, John. Mike Kaler has to leave in a few minutes. Isn't that true, Mike?
Just for a bit, but don't let me stop anything. I'm okay.
Before you go, I just want to ask you a question because I don't know how long we'll be going. Eversource is not seeking any zoning relief in this case, are they?
I think there's a record request pending where we're going to be answering that question more directly and more thoroughly.
Oh, okay, all
I
right.
think it's our EFSB 4.
Okay,
Yeah.
good. All right.
Bob, I believe that Eversource did not wish to testify, nor did the attorney for the company. So I think the way we handled it was a record request.
All right, thank you. Excuse me, Joan, go ahead. Question.
Now you're expecting me to remember the rest of my question. So we're talking about the noise wall, and we're talking about the town had requested for some landscaping or vegetation to be placed on the outside of the noise wall next to 109. Is that correct?
That's correct.
Would that landscaping or vegetation provide any additional noise attenuation?
No, our Ryan Callahan, our noise.
Sorry, I couldn't understand you. I'm sorry. No, our
Ryan
what?
Callahan, Epsilon and Ryan Callahan, the folks that conducted the noise analysis have informed me that vegetation and similar types of things do not mitigate noise. And Ryan could perhaps elaborate on that if probably better than I can.
I'm fine with that answer. Did the company consider placing the BESS equipment further away from Route 109? And if so, why did the company not choose that configuration?
It goes back to what Mark Bergeron was describing earlier about the site layout and the constraints with which we were faced with the limited space to reduce our impacts to the resource areas. So the project has filled the usable space and can't move any farther from the street.
You said it cannot move farther from the street?
Yeah, without having additional impacts to a buffer or a wetland area.
This is Mark Bergeron. I'll just add for the record, if you wanted to review or refer to figure EFSB LU -2 it will give you a good visual of the wetland resource area boundaries on the project site. And what you'll note is as you go further to the south on the project site, the vegetated wetlands extend further into the site, creating a restriction of use of that portion of the site for development. You can also see this as well on any of the site plans that we've submitted with attachment D, shows the wetland boundary as well.
Okay, great, thank you. And I remember that too from walking on that site. That's it. I think that's the end of my questions, this line of questioning for right now. Thank you very much. I don't know if actually Mr. Yorkis wanted to follow up on this line of questioning. I know that this was an area he was interested in. If I can suggest that, Mr. Shea.
Sure, Mr. Yorkis, do you have any questions on this area, this line? You're muted, sir. You're muted.
I do.
Go ahead.
And it would be very helpful for someone to explain why an alternative layout of the battery storage facility units cannot be implemented with and still minimize the impact on the wetland. And the reason I'm asking the question is I've looked at the site. I've not been on the site, but I've looked at the plans. I've looked at wetlands mapping. And I think a different configuration is available. And I've listened very carefully to the statements that have been made, and in all candor, so everybody understands this, I've been a chairman of a conservation commission, and I've been a member of a conservation commission, and I understand the wetlands regulations pretty well. And I think there are, despite the statements that have been made today, I think there are alternatives that have not been explored. And I really would like to know why an alternative which would relocate some of the 141 units further away from Route 109 Milford Street are not possible.
This is Mark Bergeron. With respect to our alternatives analysis, I'll just say that, and if you're familiar with the Conservation Commission and the performance standards, the burden of proof on the applicant to show that they've done a thorough alternatives analysis for work in the riverfront area is something that we have to undertake, is something that we've done for this project. And so what you have to consider in this instance is that it's not just the best units that you're trying to locate outside of the wetland resource areas. You've got to make this site work from an engineering perspective that ties in your project substation, all of the best units, roadway systems, any parking spaces requested by the fire department, the roadway system itself, and also the stormwater management system. So I can just say that as presented in our SEIR, and as will be presented in our notice of intent to the Conservation Commission, we've done a thorough alternatives analysis to minimize impacts within the riverfront area on the site, as well as the 100-foot buffer zone. We have to also consider that the town's local bylaw has a 25-foot no disturb zone, so we've got to honor that also. And we have worked with the company to locate the project and all of its components to minimize impacts within wetland resource areas. Also to meet the stormwater management standards. Again, the stormwater management system has to be located in a place where it works. And it's also been designed in accordance with not only the DEP stormwater standards, but also the climate and resiliency policy, the RMAT guidelines, which accounts for designing the stormwater management system so that it is sized appropriately to consider future precipitation events of higher volume and higher frequency as well. So all of that considered, I will say that in the latest iteration of the site design, again, we tried to minimize disturbance in wetland resource areas. And as noted in our SEIR section 1, the site layout shifted to the west to basically address the town's comments related to stormwater.
Thank you for that explanation. I appreciate it, and I can't offer an opinion, so I won't. But I appreciate it. But I do want to go back, if I may, Mr. Shea, to a response, that was made by Mr. Kaplan, and Mr. Kaplan was asked if the town wanted a translator and the town responded no, if I heard Mr. Kaplan correctly. And my question is, who from the town of Medway indicated that a translation service was not needed?
I believe it was Mr. Boynton, but I did not, I'm not actually testifying. I was just commenting that I do believe that the town, actually, I think Mr. Adams answered that the town, okay, Mr. Lyons answered that the town, we did ask the town if alternative language translation was necessary other than English. And I believe the response was no.
I don't recall the individual.
Can Mr. Adams expand upon that?
I was going to say, I don't recall the individual that said that it was not required, but it was the town. It was in a meeting with the town.
And that was not required is translation services.
Correct. Yeah, translation services.
Thank you.
This is Mark Bergeron. If I may just add a little bit more to the conversation here as far as translation services and what the company was or is required to do, specifically related to the MIPA, Environmental Justice Protocol. This protocol establishes additional outreach which do involve translation services. In instances where a proponent proposes a project that's within a mile of a mapped environmental justice community, or in the case of a project that results in anything that breaks a threshold in the MIPA regulations for an air emission or traffic within 5 miles. So I will say that there are no EJ communities mapped within a mile of the site. And there are several EJ communities mapped within 5 miles of the site, and these are all located in Milford, Massachusetts. Of these, 4 of them are characterized as minority, and 1 is minority English isolation. And again, because this project did not create any air emissions that would impact air quality, there were no EJ populations mapped within 1 mile of the site. The enhanced outreach protocol required by the environmental justice protocol in the MIPA policy did not apply to this project.
Thank you very much. To use Mr. Shea's often used phrase, that was very helpful.
You're welcome. And just one more point on that, if I may, just for clarification. Our response to EFSB G27 also provided Department of Public Health information, which also in that report, if you look, identifies minority or non-English speaking populations in the town of Medway and represents that I believe it's less than 2% of the population in Medway is non-English speaking.
Thank you.
Hey, may I have one follow-up to that, please?
Of course.
To the company's knowledge, did anyone request translation services for any of the activities the company has performed in Medway?
We haven't received any requests for that. No.
And I will also confirm that as part of any of the permitting processes, as far as MIPA, no translation services were requested by any person in the public that had any interest in the project during the MIPA process.
May I respond for a moment?
Well, if you have a question, I happy to hear your question, but please limit it to a question.
I'll put it in my brief.
Okay, thank you. I appreciate that. Okay, does anyone else from the siting board have any questions on consistency? If not, I'll move to zoning. So zoning, I'm going to refer you to the response to MEP-31.
Okay.
Okay, the response says the round trip efficiency of one Megapack 2 XL is 92%. Excuse me. So that's an interesting statement, but I'm not sure that I know exactly what it means. Could you expand on that, please?
Sure, this is Jason Yedinak. In my previous response on losses, I provided an example of where the energy, that 8% is going. And I can repeat that answer here.
I'm sorry. I'm sorry. I provided an example of where what?
The losses that make up the 8%, so that results in a 92% round trip efficiency. And I can go over that again.
Yeah, please.
So from the point of interconnection, where we deliver the energy to the grid, there is 1 to 2% losses coming through our main power transformer, through the substation, and to the Megapack 2 XL units. From there, the power conversion system or power electronics are roughly another 2% of losses. And again, all these losses are heat generation from current, or in the case of the power electronic equipment, IGBTs. From the power electronic equipment, the batteries get warm as they are charging and discharging, and that is another 4% or so. And that is one way coming from the point of interconnection to energy going into the batteries and changing the chemical makeup of the battery cells. Then you have those same losses going back out, which is how it is considered a round trip, energy going from our point of connection into the battery cells and then back out again. So you take those loss factors, multiply them together, and you get, again, roughly order of magnitude of 92%.
That's very helpful. Thank you. The project would be able to store 500 megawatts, but more than 500 megawatts would have to be taken off the grid to allow the project to store 500. Is that correct?
Correct. With one correction, 500 megawatt hours. So a unit of energy is megawatt hours. Power is megawatts.
Okay, so thank you very much. In order to store 500 megawatt hours, do you know how much energy the BESS would have to take in?
You could take 500 megawatt hours and divide by the one-way efficiency of the system, which would be the square root of 92.
500 megawatts.
I can do that calculation if that's helpful.
That would be helpful for a good example. So 500 megawatts divided by the square root of 92.
That is over my head, Mr. Shea.
So one way is approximately 96%. $500 megawatt hours divided by 0.96 is roughly 521 megawatt hours would go into the system, at the point of our interconnection would be the energy flowing into our system in order to export out 500 megawatt hours.
That's very helpful.
Approximate, yeah, approximate.
Yeah, no, I realize you did this on the spot, and I appreciate that. One of the comments, one of the criticisms that was made in connection with the public comment hearing was that there are inefficiencies in the BESS storage system, which we've just discussed, and that there inevitably would be some inefficiencies in the original generation, and therefore that the idea that that BESS is efficient is a little bit of an illusion, and that was my paraphrasing of a comment that I heard either at the public comment hearing or something that was submitted in writing.
You following?
Yes, do you follow what I'm saying? That so one of the criticisms was that while there are inefficiencies in the BESS system, there's probably some inefficiencies in whatever entity generates the energy that's coming in. So therefore, the BESS really just the BESS doubles the inefficiencies, and that was a criticism of the use of BESS. How would you respond to it?
Orders of magnitude difference would be my response.
Oh,
This level of efficiency is again, it's hard to do apples to apples comparison to conventional generation, but it is.
I'm sorry, it's hard to do it. I'm sorry. Wait. It's hard to do an apples to apples comparison. What?
To conventional fossil generation, but I can't imagine that its fuel conversion efficiency is close to in the 90% or even the high 80s. So this technology is extremely efficient.
Okay, and it would be efficient. I've used the, I beg your pardon. I've used the example before of, or let's say the parallel of a peaker plant. The peaker plant could be built that would do some of the things that the BESS might do. And do you have any general idea of what the general efficiencies of peaker plants are?
Just 1 minute, we can consult and provide a response.
Oh, that's very helpful. Thank you.
I'm ready to respond. This is Jason Yedinak. Conventional generation would have the same line losses, transformer losses that we have, which is a few percent as well. So if we focus just on our technology that is in the mid 90s as far as efficiency goes, compared to natural gas facilities, which we are in the order of 60% efficiency as far as amount of waste heat goes, and with coal facilities that are on the order of, say, 30% efficiency. So we're looking at mid 90s% compared to 60 and 30% of conventional fossil fuels.
Thank you.
Those are approximate numbers based upon our search.
Thank you. I appreciate that. I'm going to go to segue to another line of questioning. Looking at the response to EFSB-Z-7.
This is Sam Lyons. I'm there.
Thank you, Mr. Lyons. Now, I asked in the question, what would the consequences be to the company if construction of the project was to be delayed by 6 months or a year or 18 months? And the answer was that the company would face significant financial consequences. But there weren't any numbers attached to it. What I'm wondering about is there any way you can attach numbers to these significant financial consequences? Because that's something that people might want to know in the decision.
Hi, this is Sam Lyons. The financial consequences to the project arise. Well, there are several different ways that it arises. There's the opportunity cost of not being in the market, but I think more directly, the direct financial consequences come in the form of penalties for not meeting our capacity supply obligation date. Those include requiring us to cover our capacity commitment through other means. We would need to replace that capacity with something else. Otherwise, we are liable for the full cost of that capacity as a penalty. In addition, we are liable for capacity scarcity penalties that arise under the pay for performance program. In addition, the ISO, if the project is delayed by any more than 24 months, can cancel our capacity supply obligation completely, resulting in the loss of all future revenues pursuant to that. And that endangers the project on the whole as well. So the amounts of those are pretty broad, depending upon our ability to cover that capacity and the prevalence of potential capacity scarcity events during those periods of time, but are quite high in a broad sense.
Thank you. Let's go to next to EFSB-Z-9.
Okay.
Now, in the answer to that, I believe you state that, well, in the question and the answer, in 2019, a 2 megawatt and 2 megawatt hour BESS in Surprise, Arizona experienced a fire. And in the answer, you asserted that said BESS was installed, quote, prior to the implementation of the safety standards in place now, close quotes. So please explain to which safety standards you are referring.
Yes, this is Paul Rogers. I would be able to give you some insight on that.
Thank you.
When the design for the Arizona Surprise energy storage system was put together, it was put together on codes that were not sufficient to handle the hazards that were part of a lithium-ion battery failure. Since that, there have been numerous things put in place, codes and standards, in order to address safety, so we would reduce the risk of something like that happening again.
And when you talk about codes and standards, do some of these relate to the UL codes that you talked about last week?
Yes, you will have the NFPA 855
Okay.
stationary energy storage installation standard. You'll also have some product codes that are out there, UL 9540, UL 1973, UL 1741, UL 1642, and UL 9540A, which is a large-scale fire testing looking at thermal propagation.
So none of those codes were in place when the facility in Surprise, Arizona was built?
No, some of those codes were in place. For instance, 1973 was in place at that time, UL 1973, and also UL 1741.
But a lot of
I
those.
believe UL, I'm sorry.
Go ahead, I beg your pardon.
No, I'm finished.
Oh, so, but is it true that some of the codes you referred to were not in place when the Surprise, Arizona BESS was constructed?
That is correct.
Can you mention which codes in particular were not in place at that time?
Yes, UL 9540 was not in place, which is a product code for the complete system of the energy storage system. UL 9540A was the testing methodology used for thermal propagation with an energy storage system. I can get the exact name of that. Give me a second. So UL 9540A, the exact name is the Standard for Safety Test Method for Evaluating Thermal Runaway Fire Propagation in Battery Energy Storage Systems.
Okay, thank you.
And last but not least is NFPA 855, which is a standard for the installation of stationary energy storage systems.
All right, thank you very much. I'm going to go to another line of questioning. It's really just a solo question. Could I ask you to look at the EFSB-Z-11?
Okay.
Okay, the question asks about the concept of shape factor. And I've seen the answer, but I don't really understand it. Let me walk through the concept. The shape factor is the square of the lot perimeter divided by the lot area. Is that correct? Is that correct?
Yeah.
Okay.
Yeah, it would be the length of the square of the length of the lot line divided by the lot area.
All right, so let's say we had a lot perimeter that was a square and it was 20 feet by 20 feet. So that would be, I'm sorry, I wrote this out for, let's say it would, a square of a very small lot be 5 feet by 5 feet. So the lot perimeter would be 20 feet. And the square of 20 would be 400. Okay, am I accurate so far?
I think so. Yeah.
That's a square of the lot perimeter for the 5 foot by 5 foot lot. The lot area let's see, the lot area would be 25 square feet, wouldn't it?
Yes.
So which do you divide into to which? 25 into 400?
Yeah.
You
25
divide
and- right.
So you divide the area into the square of the area into the square of the perimeter. So you divide 25 into 400 and you get 16.
Right.
All right. Now tell me, how would a shape factor get as high as 22? I mean, just give me an example of how that would work.
That what they're trying to prevent are irregularly shaped lots, which have very little frontage, and they might be shaped like big triangles or. So I think if they had a very long lot line with a very small area, so it'd be like a really, really long and narrow lot. The goal is to prevent irregularly shaped lots that are impossible to construct anything on.
That's a very interesting concept. You mentioned, something that would be very long and narrow would have a high shape factor, but it would be impossible to construct something on it.
Right. Yes.
So that's one example.
And developers, they have motivations for why they would want to do that. I'm not sure what they are, but it's something towns don't want.
Okay. Now, this is something that puzzled me. Maybe you can enlighten me. The words, that portion of the lot in excess of that portion of the lot in excess of the required lot area may be excluded from the computation of the shape factor.
That's right.
Puzzling to me. Could you explain that?
We have a required area, I think, of 20,000. It's on our site plan. The minimum area required for AR2 zones.
Sorry, I can't hear you, Mr. Adams. Minimum area required for what?
AR2 zoned lots of 22,500. Oh no, it's 30,000.
When you say 30,000, I'm sorry, what does that refer to?
Square feet for the
30,000.
minimum lot area.
Is that what's required to house the BESS? Is that how you get that as minimum?
Well, so these standards are written for AR2 zones related to zoning. 30,000 is what the town publishes as the minimum lot area for a lot within the AR2 zone in order to construct a two-family home or a single-family home with detached housing.
All right, so that gives me a good sense of the required lot area. Now, in your response to B from EFSB-Z-11B, you say to calculate the lot shape factor, the quote imaginary lot line would need to be determined. Unfortunately, I'm entirely lost now with what is the imaginary lot line?
So that would be the lot line around the required square footage, as long as the entire required frontage is part of that. I mean, and this calculation is difficult to do.
Okay, so the imaginary lot line is the line that would describe the required area according to the zoning bylaw.
That's right.
Okay, well, I certainly understand more than when we started, and I appreciate that. Now, let me address your attention to EFSB-Z-12. And in response to that, well, I'll wait to get there.
This is Sam Lyons. I'm there.
Okay. In that answer, the company states that the factors, quote, the factors bearing on the public convenience and welfare do not necessarily stop at the Commonwealth's border, period, close quotes. What exactly do you mean by that? Or can you expand upon that?
I don't have too much to add to the legal definition that was provided. But I believe that the thrust of that was that a certificate or a ruling of convenience and public necessity within the Commonwealth doesn't necessarily limit that convenience and public necessity to the members of the Commonwealth itself, but could apply to the region more broadly.
So the impact of the project on climate change, even if climate change is, we don't have a Massachusetts climate change and a New Hampshire climate change. It's a bit broad. So, but the impact on climate change is part of the public convenience and welfare. Is that accurate?
Yes, I think that's accurate.
Okay, good. Now I'm going to address your attention to the answer to MEP-17. I'll have to grab that.
Okay.
All right. Yeah, in MEP-17, your answer states that, quote, the town has a moratorium in place that precludes construction of a BESS. Thus, a comprehensive zoning exemption from the town of Medway's bylaws is required for construction. That makes sense. But we introduced a piece of evidence earlier in the case. I don't know if you saw it. I sent it out. It's exhibit EFSB-1. It's a letter from the Office of the Attorney General to the Town Clerk of Medway regarding amendments to the bylaws that provide for a moratorium on building a BESS in Medway. And I'll quote from it. It says, this is the Attorney General's office. Because the moratorium is limited solely to the town's energy resources, ER zonings district, it does not apply to the pending application by Medway Grid LLC to the Massachusetts Energy Facility Siting Board to construct a standalone battery energy storage facility, including a new electric substation. So that opinion by the Attorney General would seem to contradict your answer. Do you have anything to say on that? If you don't, I can put it as a record request, because to some extent it's a legal question.
So that's true. The moratorium would prevent the construction of a BESS within the ER zone. We are in an AR2 zone, which also has no pathway to being permitted. There's no use allowed in an AR2 zone consistent with ours.
Okay, I understand that, and you've articulated that well in the zoning exemption petition. But the moratorium, does that, as you understand it, does the moratorium that was passed against construction of a BESS in the energy resources zoning district, does that directly affect your project?
As we understand it, the moratorium would affect our interconnection facilities, which do go into the ER zone.
Okay, that's very helpful. Thank you. Now I'm going to direct your attention to MEP-9. That question incorporates by reference the response to EFSB-G-22. And in that response, the company states that, quote, all day-to-day or operational requirements will be managed by the company with support from third-party vendors. So MEP-9 asks the company to specifically identify these vendors, and the company that replies that it will choose the vendors before operation. Now, my question is, have you chose any of these vendors now at this time?
No, we have not.
Okay. I just want to make it clear, you understand the company is under an obligation to supplement this answer when any information relevant to it becomes available.
Yeah, once approved, or if approved, sorry, we would be willing to provide that information if needed or requested.
Well,
we would not be hiring any vendor until we're sure that we have the ability to proceed. So I think what Mr. Adams is saying is we're happy to provide that information, but it would probably be after the decision by the EFSB.
All right, that's helpful. Now, my last question relates to, I believe I put this question to the Mr. Boynton from the town of Medway representative, but I'm not sure if he answered it or if one of you represented it. It's about the property value security fund in the host community agreement, section 60 of the host community agreement.
Okay.
Now, that provides for individuals to get compensation for loss for declining property values. And I'll ask you the same question I asked Mr. Boynton, not to be repetitive, but just to make sure that there's a meeting of the minds here with respect to this contract. Is the homeowner required to sign a release of the company in order to receive money from the property value security fund?
I'm rereading what was written.
Sure.
No, the homeowners wouldn't be required to sign a release.
Okay. So if the homeowner receives compensation from the property value security fund, that homeowner is not giving up any legal rights, is he or she?
No.
All right, that's very helpful. Let me just look for a second. I think I'm all done. That's all the questions I have. Let me ask my colleagues if anyone else on the siting board has questions on those matters, zonings and consistency.
None here.
Mr. Green, okay, none there. And I'm not hearing anything from any of my other colleagues, so,
I'm all set. Thank you, Bob.
okay, sure. Thank you. Thank you, Joan. Mr. Yorkis, do you have any questions on those matters?
Well, you have already asked some of them, so thank you.
Okay.
I won't ask them again. But I have concerns, but we'll take them up in the brief.
Okay, all right, that's very appropriate. Thank you. Mr. Kaplan, do you have any redirect?
We do, if we can just have a few minutes.
Sure. How long would you like?
May I suggest that we take our afternoon break?
Yes, let's take our afternoon break. I'm sorry. Let's take our, at least, we're probably getting close to being done. So let's take a 14-minute break. Let's take a 15-minute break. It's 3:16. I'll see you at 3:31. Would that
Okay,
be
perfect. Thank you.
acceptable? All right. Off the record. Pardon me, Alan. I should have thought of you before this.
No problem. Thank you.
Are we ready to resume? Is there anyone who should be here who's not? I think we're all here. Can we go back on the record, Alan? Mr. Kaplan, did you have any redirect? And I should note that you're muted. Yeah, you're still muted, unfortunately. Mr. Kaplan's microphone seems to be muted. Maybe there's a technical difficulty. Do you want to send me an email?
He's unmuted
Okay,
now.
we're,
Oh, good.
I think,
good,
I
okay.
think we were, I think we were muted on your end. I apologize.
That's right. Don't worry.
So the company just has some quick redirect, and Mr. Connolly is going to be handling that on behalf of the company.
Thank you very much.
Good afternoon, Mr. Shea.
Good afternoon,
Paul
Mr. Connolly.
for Lieutenant Rogers, I just have a couple of questions. Just a few minutes ago, you mentioned the safety standards that were in effect for battery storage systems. Do you recall that?
I do.
And you mentioned NFPA 855. What does that safety standard do?
NFPA 855 is a safety standard for the proper installation of stationary energy storage systems.
Has that safety standard been incorporated into the Massachusetts Comprehensive Fire Safety Code?
That safety standard has been incorporated into the Massachusetts Fire Code indirectly through NFPA 1, which is the Massachusetts Fire Code, which points to NFPA 855 in that NFPA 1 standard.
And does NFPA 855 reference large system testing?
Yes, NFPA 855 does require large-scale fire testing for the energy storage system itself.
And is that testing done under the UL standard 9540A?
Yes, that's the inside the NFPA 855 document on the large-scale fire testing that points to UL 9540A.
And who does the actual testing under 9540A?
The testing performed under 9540A is done by a nationally recognized testing laboratory.
Thank you. That's all we have.
Thank you. Does anyone else have any questions? Hearing none, I'll say that we should conclude the evidentiary hearing portion. And then the next matters have to do with scheduling. But I'd like to talk about them off the record, and then we'll want to make decisions. We'll go back on the record. So Mr. Brock, we can go off the record right now. All right, so there were about 9 or 10 record requests. I think there were 9. So normally we get the record requests, we ask for them a week later. I'm trying to figure, do the scheduling so we can set a deadline for initial briefs and reply briefs. Is there any reason that wouldn't be possible to respond to the 9 record requests within the next week?
So I think there might be 10, but
10?
I believe 9 went to the company, and we would have no problem getting that back to you within a week. I think one of the questions was asked of the town. Eversource is with us.
Oh, and the town had the emails.
Right, the town with the
6
emails.
emails.
So, and it sounded like, I can't speak for the town, but it didn't sound like that was going to be complicated to respond to. Right. So that shouldn't be a problem.
All right, that
Can I-
sounds,
While we're off the record, can I ask a question about record request number 2?
sure, you have to remind me which one that is.
Sure. So that was pertaining to the cost of the project.
Uh-huh.
And Andy Green had asked it, and I'm wondering if we can sort of talk through what you're looking for, because while it's true that the EFSB can consider the cost in a zoning exemption, you don't have to. And in this case, given that the company still needs to negotiate its pilot with the town, which is a party to the case, and we're working on the costs for the upgrades with Eversource, which is also a party to the case, and that one of the limited participants in the case is a competitor of Medway Grid, us providing the cost of the project to you is really financially detrimental to the company. And so I'm wondering if there's a way to do this that gets you what you were hoping to find out and doesn't have us provide really financial information to competitors and the folks that we're negotiating with.
Yes. Mr. Green's here. So Mr. Green asked that question. What do you think, Mr. Green?
I think it was Dr. Green, but okay.
You're muted.
Yes.
Yes.
Okay. I do understand your concern, Mr. Kaplan. I'd say the question relates to an area of general interest and is perhaps not central to our findings in the case, but you never know when and how it might be useful information. So I'm not sure how to mask or somehow, transform that information into something that's not compromising from a business information standpoint that's still useful to us.
Can I ask, is it possible? I don't know if this is possible, but is it possible for us to send in the answer just to you? I mean, to the EFSB and provide a redacted version to the other parties in the case?
I will defer to my counsel on that point.
Well, this is something that happens a lot, that a company with commercially sensitive information would provide a redacted copy to the public and then an unredacted copy to the siting board, along with the motion for CEII treatment, confidential energy infrastructure information. And there's a lot of
That the town prepared in response.
So I think they're talking about cost, Bob, which is not CEII. That would come in under a section 5D motion.
Right. Well, CEI it's right. It's not CEI, but it's closely related. There's a right. Section 5D provides that there is information that's not considered public record information, and
Charlie Myers just.
and can be redacted, and that's very common to happen. Now we'd have to get the motion, but Joan, what do you think?
Well, I think that Andy Kaplan is talking about not providing it to the other parties, which is a very different thing. Usually, confidential information comes in subject to a motion, but the parties are allowed to sign an NDA with the company and still get access to the information. I think Andy Kaplan's looking for something different.
Right.
Which is not the
Joe.
normal. Not providing it to the parties to a case is not the normal arrangement.
Correct. And that's why I'm asking, because in this case, the parties have an interest in finding out what that number is.
Well, one option, and I'll see what my colleagues think of this, would be instead of answering the record request, to just file a motion to be excused from answering the record request, or file a motion to send the information just to us, but not to anybody else, or just a redacted version to anyone else. And then when the motion's filed, if anyone wants to object to it, they can object, and we can make that determination.
Before we go there, could I just offer an observation that my recollection of when I asked that record request, we did have information that was from June that had a cost figure for the project that was stated on the record by the company. I think that there was a number that was presented, and I asked for an update of that number. So the record has some information already on this point, and perhaps it would be possible to respond to the request with a high level update, not necessarily breaking it down into categories or specific items that may have changed, but just still to keep it an aggregate cost figure.
We can definitely do that.
Would that address your concern, Mr. Kaplan?
It would. Thank you.
Okay, so
let me just make sure. I actually want to make sure I understand it. I think it addresses my concern. Just sort of either a range or some information that allows you to know where things are going or where things are headed without giving you a specific number.
Well, if your response were costs have gone up, that wouldn't be very illuminating.
Right. I wasn't thinking that.
But if you said, relative to the figure provided on transcript 2 at line 47, costs have increased 25%, that would be more useful.
Yeah, that probably still gives the information that anybody can figure out. But I mean,
oh yeah, if you have a slide rule, sure, but not everybody does.
What about withdrawing the request? It's just a general request. Letter.
So what about providing the information, what Andy Green's looking for, consistent with the level of information or the type of information you've already provided on the record? If you've already provided a number on the record, then updating that figure in the same manner would probably satisfy Andy Green. Is that right, Andy?
Yes, it would.
Okay. All right, we'll do that. And then if you guys have specific questions from that, just let me know.
Okay, we'll go on the record.
Hopefully that'll be responsive to your question.
It sounds like it will be.
We'll go on the record to memorialize this. But before we do, Joan, did you have something?
Are you going to go back off again for us to discuss scheduling?
Yeah, I want to put it on the record, and then I also want to make the motion to admit all documents marked as exhibits into evidence. So, and then we'll go off and talk about scheduling.
Oh, actually, before we do that, there's a couple of objections to some of those, and I just wanted to, or we can let them in with the objections. I don't care.
All right. Well, why don't we get the objections on the record? Can I go back? Can I go back on the record?
Sure.
All right. Now, off the record, we had a discussion about the response to record request EFSB-2. It asked for some cost information. I believe Mr. Kaplan's position is that this is very sensitive information because not all the costs have been nailed down yet. The company is negotiating, and to have every cost estimated and out there with the people available to the people that you're negotiating with and against is very difficult, very harmful to the negotiating position. So I believe that the agreement was that there's already a number out there in the record about the cost, and that there's already a number about there's already a number in the record about the cost, and that what would satisfy us is not a specific number. Don't give us we don't need a specific number as to how much things would cost, but rather a more general update, not so general as to be useless, as Mr. Green said. If the response is just, well, the cost may be more than we had previously anticipated, it's not that helpful. But if there could be something of a range or something that would give us some meaningful information, but not undermine the company's negotiating position, that might be a little difficult needle to thread, but if you can do that, that would be very helpful.
And let me just clarify that what might be helpful, it sounded like from our off the record discussion, was to leave the cost update at a very high aggregate level and not breaking it out into its subcomponents or specific categories. At least that was my understanding.
Okay, that sounds fine. That sounds like a good solution. Mr. Kaplan, what do you say?
We have no problem providing that information.
Okay, that's very helpful. The next
And
matter.
we appreciate your consideration.
Thank you, Mr. Kaplan. The next matter is to move all exhibits that have been marked as marked for identification into evidence. And then after that, we're going to address scheduling. But first, I move that all the exhibits that have been marked for identification in this case be moved into evidence. And that would include even things like answers to record requests, which have not yet been filed. And perhaps there are some supplemental answers to information requests. So all of that being moved into evidence. That's the motion. Are there any objections?
So the company just notes that MEP, there were two IRs that the company objected to. One was MEP 32. And in that case, MEP testified in its answer or in its information request, testified as to how much water would be used to, in their opinion, suppress 5 best thermal events. And that was a question that was asked of the company originally by EFSB, and there was really no way for the company to ascertain that. So Dr. Yorkis came up with a number, but the company, I mean, I'm not sure how he came up with that number or why. And so, and I don't think that's an information request. I think that's a statement. So I object to having that admitted into evidence, at least for consideration as to the amount of water that might need to be suppressed, might need to be used to suppress 5 best thermal events. And the second objection was MEP 45.
Why don't we do one objection at a time?
Okay. Okay.
Yeah. All right. I'm looking at this, the MEP that you mentioned. And I see what you mean. The question from Mr. Yorkis, and you will get a chance to talk, Mr. Yorkis. I'm not going to hog the floor here. It says, I'm going to quote, for example, a 6-hour use of defensive water spray by a single stream now.
I'm sorry, Bob, I couldn't hear. For example, a 6-hour use of what?
Of defensive water spray by a single stream nozzle at 750 gallons per minute would use 4,500 gallons per minute. A two nozzle defensive stream for the same time period would result in the use of 9,000 gallons per minute. And the objection is MEP is providing its informed estimate pertaining to the amount of water that would be used to address 5 best thermal events. Okay, so, and then it goes on to the company's knowledge, Mr. Yorkis, who's made the statement, is neither a professional engineer nor firefighter. And of course, in making that statement, Mr. Yorkis wasn't testifying under oath. So that's one of the information requests, at least the testimonial part of it, you object to. Is that correct, Mr. Kaplan?
That is correct.
Okay, Mr.
Yorkis,
Yorkis.
having that information on the record without having any knowledge of how, I mean, we have Lieutenant Rogers, who's a New York City firefighter, and he could not ascertain that response because of all the different contingencies that go into fighting a fire. So it was hard to figure out. So I just don't think that that is a valid response, and I don't know where it came from.
Okay, let me ask Mr. Yurkis how he responds to the objection. Now, you're muted right now, sir.
Thank you. I put myself on mute because our dogs were barking. I apologize. I understand the objection. And I think, however, it is possible for the applicant to come up with a number. So the attempt that I made, and I am not a firefighter, nor am I an engineer. I agree with Mr. Kaplan's statement, but I think the answer is still important. And so I would ask Mr. Kaplan how he can answer the question, not he personally, but how the applicant can answer the question.
Well, let me address that to an extent. Your question adopted an earlier EFSB question, and your question, MEP-32, adopted the EFSB-W-2 question, which was, please identify the volumes of water that have been used at best thermal events worldwide in the last 5 years. That was section A. And B was, what was the total volume of water used to address the 5 most serious best thermal events listed in response to information EFSB-W-2A above? Okay, so it asks for specific volumes of water. The response is A, this information is not publicly available. The manufacturer of the Tesla Megapack 2L XL has recommended against extinguishing a potential thermal runaway with water. B at C above. So the siting board had asked for some very specific information about water. How much water would it take, and to address, or how much water has it taken to address really severe best events? And the response is the information isn't publicly available, and the manufacturer advises against using water and to suppress fire. So tell me, Mr. Yurkis, why is that not a sufficient answer?
Well, first of all, and thank you for your question. I think it is important to understand a worst case scenario.
Yes.
And I think, I don't know, I don't want to mislead anybody. I don't know specifically who or why someone within the EFSB decided to ask the question, but I think it's a very valid question. I understand, and it's been repeated multiple times, that Tesla has indicated that water should not be used to extinguish a fire. I get it. I'm a pretty astute reader. But I also understand the unpredictable nature of things. And while it says that it should not be used to extinguish a fire, I understand that. But we also have discussed, if my memory is correct, the idea of using water to ensure that a fire does not spread. And so I think that this is a very relevant question. And I think minds and experiences much better than mine should be able to come up with a response.
Okay, Mr. Kaplan, what do you say?
I mean, it may be a relevant question to Dr. Yurkis, but it cannot be determined. So the statement that he's making of the amount of water that it could take in a worst case scenario where you're using water on containers next to one that might be on fire and not putting water on the fire, I don't know how he can figure out how much water that would take. And I can also tell you that we couldn't figure out, and we tried, and we have experts here, we could not figure out how much water was used in the previous fires. So I don't know how Dr. Yorkis could come up with that calculation when the information is just not publicly available. So for Dr. Yorkis to say that I think, the company can come up with a number, because I came up with a number, that's, I mean, that's just not relevant.
Is
And,
there something,
I think,
is there a number that could be, that we could get from a previous fire that would give us any, I don't know if there's a similar type of facility where there's some kind of fire that's happened in the past that would give us a, like a range or a general volume of how much water it takes to put out certain types of, maybe some kind of electrical fire. I don't know, maybe Lieutenant Rogers has something that he could say, okay, well, here's something that's somewhat similar. I don't know if that's a possibility.
so, I mean, look, we can say how much water it might have taken one fire department to put out a fire that happened at a Dunkin' Donuts, and how much water was used in another fire at a different Dunkin' Donuts. But I don't know how helpful that is, and I don't know where it leads. And I'm not sure, I mean, I just don't know. I get where you're coming from, I really do. I just don't know how to get you that information. And I think that the information on what happened in previous fires wouldn't, by testing shows, wouldn't happen in this case anyway, because they're totally different batteries. And there's different manufacturing recommendations on, not putting water on fire as opposed to trying to extinguish the water. But it comes back to Dr. Yorkis just inventing a number of how much water he thinks is going to be used if this facility catches on fire. And it's just not, there's no logical connection between what he's saying and reality.
May I respond?
Yes, please do.
Thank you. Mr. Kaplan, I'm happy to take out my theoretical response, but I still believe that the response, an estimate, is possible and needed. And let me expand on it, please. The idea of the way the drainage system is designed is supposed to be for a specific amount of water and under specific as well as unusual natural events. I understand that. We're not talking about that. We're talking about a different kind of event where the public safety in this community has to become preeminent, and how that water, the amount of water, and how that impacts the proposed detention pond. And it's not simply to somebody saying, well, we need to know an answer. We need to know an answer because it relates to public safety, it relates to environmental safety, and I really would advocate additional work be done to come up with an estimated number with all the caveats that you think need to be included, but at least have a number so we understand what the potential impact could be.
Mr. Yorkis, it seems to me though, just to say, I think though that, Mr. Yorkis, what you've just done is you've written part of your brief. You've said there's a bit of information that was asked and the response is, to your mind, not sufficient, and therefore that's a fault that's a demerit, that's a reason not to approve this project. I think you've got your argument. I don't think I can well, I certainly can't order Mr. Kaplan to come up with a number when he tells me that he can't come up with a number. But I think that what we've got here is more of an argument than an actual question.
Could I ask one more? I'm trying to come at it from just a slightly different angle. How does the company know that the water on site, I'm sorry, I can't remember. You must have hydrants there, I'm assuming, or will have hydrants there.
Yes, the fire department asked for 5 hydrants to be put on the site.
So do you know?
There's a 12-inch water main.
And there's a 12-inch water main, so the fire department, yeah, I'm sorry. Go ahead,
So do you have any idea how the fire department determined that was adequate?
They'll do a test. They'll do a flow rate test for the main, and then they have a calculation. I don't know the specific numbers, but then they have a calculation that says, yes, that main can provide enough water pressure to those 5 fire hydrants, pressure and volume.
Now, isn't there going to be some water stored on site, if I remember correctly?
No, there won't be any water stored on site.
Okay.
So if the fire department, again, I'm trying to get it from another angle if possible, just to get, so if the fire department made a determination that these 5 hydrants served by this 12-inch main are sufficient to provide a certain quantity of water to the facility, how did they determine what that quantity of water is needed at the facility? If you know.
They're I know that they determined the location of the fire hydrants for access to get to the event. So it's more of a distance thing than a volume thing in their minds.
What I'd be inclined to do is sustain the objection to the extent that it addresses the paragraph which is labeled as question from Paul G. Yorkis. So sustain that objection, and actually the rest of the document is in the rest of the answer and everything is in the IR, the EFSB-W-2. So my inclination would be to sustain the objection, because as I mentioned to Mr. Yorkis, I think he has an argument here. I asked a question, it wasn't answered, and then it'll be up to the citing board to determine whether the failure to answer this question or the fact the answer is not ascertainable is fatal to the petition. So I think that it's really more of I think what you've got here, Mr. Yorkis, is you've got the fuel for the fire. You've got what you need to make an argument, which is—
I don't want a fire.
Yeah, well, that's what a brief is.
Nobody wants a fire.
Right.
Yeah.
Well, a brief lights a metaphorical fire. Okay, and so
we should probably move on to the next objection, Bob.
Well, don't you want to rule on this objection?
I thought you just said you sustained it.
I would be inclined to sustain it unless someone in position of power overrules me.
I have no objections to your sustaining.
Okay, that's great. Let's go on to the next. Let's go on to the next objection.
There's only one more, and that was MEP 45, where Dr. Yorkis asked the different battery manufacturers that the company has used in other at other facilities, and
we can provide those.
I'm just wondering the relevance of that.
Mr. Yorkis, what do you think about the relevance of that?
Well, I think it's obviously, I thought it was important at the time and still think it's important that the Energy Facility Siting Board personnel understand and recognize that they are different, and the experience of the company in the energy facilities siting board making a decision, understand that there is different experiences. I'll just put it that way.
Sure. But one of the things I'm thinking about here is, if this were a thin record, that would be one thing, but it is a thick record. I am looking around at my dining room table and looking at not even all, just some of the material that's been produced in this case, and it's really exhaustive. So I sympathize with the company that at a certain point, the company wants to say, I've given you enough information. And the battery energy storage systems used at other sites, if it really was relevant, it would open up a can of worms. We could ask all about those sites, but I think the only thing that's relevant is this particular site. I would be inclined to sustain this objection also, unless, I guess, again, I'll listen to general counsel and our director if they don't want to sustain the objection. Joan or Andy, do you have anything to say?
I wonder if the question's not so much relevance, but maybe weight of the evidence. That is the way I'm thinking of it, but others might think otherwise.
Mr. Shea,
Yes.
the company has proposed building, installing, has requested the approval for a very large facility. And I think its past experience is relevant based upon what it is attempting to do here in Medway. And that's why the question was asked.
Well,
Well, it's interesting. What we're doing now is I moved that everything that's been marked as an exhibit be introduced into evidence. We don't have, we don't have any evidence here that is prejudicial to the company. Or to put it another way, the company didn't answer the question. The company just raised an objection. So how does it hurt, Mr. Kaplan, how does it hurt the company to let this particular question into evidence?
it does not hurt the company to let the question into evidence. I was under the impression that if we objected, we might have to respond at some point or not respond. But if you just want to put it in with our objection, that's perfectly fine.
All right, so why don't we then overrule this
And
objection?
that's actually the same with MEP 32. That just says an objection as well. So I'm fine with just admitting them all in with the two objections noted.
Okay, so I guess that what we'll do then is the motion is to admit everything that's been identified as it's been marked as marked for the record and identified as evidence, including the objections. And I note that there's been no motion to compel that would cause us to rule on these objections. So, does anyone have does anyone have an objection to that? To moving everything into evidence, noting that there are objections and that there was no motion to compel that would overrule the objections. Hearing no objections, the motion is allowed. Now let's turn our attention to the briefing schedule. And I think we were talking before about getting answers to record requests.
Do we want to go off the record, Bob, just to discuss this?
Yeah, let's go off the record here.
And also, I don't want to forget, I had sent Bob an email that we noticed a minor error in the transcript of February 9th, and I just have to go on the record to correct that with the language that Alan gave me.
Why don't we
So-
go on the record? You can correct that right now.
Okay.
Go back on the record. Mr. Kaplan wants to say something.
Yes, Mr. Shea, I noticed a minor error in the February 9th, 2023 certified transcript that I'd like to correct on the record. In my direct examination on February 9th, 2023, the witness answering on what in the transcript is pages 18, line 20 through page 22, line 8, was identified in the transcript as being reported as spoken by Mr. Jablanowski, but in fact, it was in all instances, Mr. Callahan.
Okay. All right, thank you for that clarification. Now we'll go back off the record. Now let's talk about the answers to record requests. Do you think that we could have those? Obviously, they're not all addressed to you, Mr. Kaplan, or to your client, but do you think we could have those within a week?
Yes, so that's oh, Monday is a holiday, Monday the 20th. Should we get
Oh,
them
it
to
is,
you on
yes.
the 21st?
Monday is a holiday, so could we have them a week from tomorrow?
Yep.
Okay.
Okay.
So that would be, I'm trying to think, today is the 13th. Was that the
21st. It would be the
Yeah,
21st.
February 21st.
February 21. All right, and let's talk about the briefing schedule. Now, I note that time is of the essence, as we often say, that well, and we had put out a procedural order dated November 14th, 2022, which had us conducting the evidentiary hearings on these weeks of February 9th and February 13th, which we have done. And then we'll get the answers to the record request of February 21. The initial briefs we're going to be doing the week of March 13th. Is anyone else getting some
Yes.
sound here?
Yes.
That's what.
Okay. So the week of March 13th, does anyone have a particular, first of all, is that still appropriate? Does anyone object to that?
That's this week, so yes.
The week of March 13th.
Oh, March 13th.
March
Oh, March 13th, I'm sorry. Like you said, February 13th.
Yeah, the week of March 13th for the
Yeah.
deadline for briefs.
Mr.
Yeah,
Shea,
no objection.
Yes, sir. Yes, Mr. Yerkes.
when you say the week of March 13th, I'm sorry, because I'm unfamiliar with what that means. Are you talking about the brief needs to be filed with you that week or on a particular day in that week?
Well, the first question I have is the week okay? If anyone's on vacation that week, it wouldn't be, might not be a good week. And then the second question is, what would be the specific day on that week?
Because I have business in Washington, D.C. on the 14th and 15th of that week.
Okay. Do you think you could produce a brief by the 17th? I mean, you'd have to produce most of it beforehand.
Absolutely, I can.
Okay. So does anyone object to the initial briefs being due on March 17th? Okay.
Somebody does not.
Thank you. Reply briefs 2 weeks later.
Yeah.
March
31,
31st.
yeah. Hey, the 17th is St. Patty's Day. You'll have to send in green briefs.
It's a holiday too.
Oh, yeah, it's evacuation day, right?
Who gets St. Patty's Day off?
We thought all state employees.
No.
No, we were hoping us, but I guess not.
It was a holiday many years ago. It was a holiday just in the city of Boston.
Yes.
I think it still is.
Bunker
Yeah.
Hill Day
Is
you're
it?
talking about?
Yeah.
Or evacuation day. I think it's evacuation day, isn't it?
Yeah,
The
evacuation,
17th,
yes,
evacuation day.
evacuation day,
Yeah.
yes.
I think the Bunker Hill holiday is the one that's in June, but now I think it's Juneteenth. I think it's the one that's in June now.
Right.
Okay. So I think we have a consensus on what we should do. I'll recite this and then we'll go on the record. The answers to record requests should be filed by February 21st. Initial briefs should be filed by March 17th and reply briefs should be filed by March 31st. Okay, does anyone object to that? All right, hearing none. Let's go back on, hearing no objections. Let's go back on the record. Mr. Brock. Back on the record. We've had a discussion off the record and we've agreed on the following schedule. Answers to record requests will be due by February 21st. The initial brief of the parties will be due on March 17th and reply briefs will be due on March 31st. Are there any other matters left to discuss?
The company has none.
Okay. Well, then I'll just say thank you very much. Everyone was very well prepared and I thought everyone, it helped us move things along very quickly. So thank you very much. And I will be looking forward to getting the responses to the record requests and to reading your briefs. If you have any questions, you can certainly email me. But does anyone have anything else for the record or any questions or anything?
Happy Valentine's
Thank you all.
Day,
Okay, then this concludes our evidentiary hearings. Thank you very much. Have a good night.
Thank you.
Thank you.
Thank you.